Good afternoon. The Senate Judiciary Committee is back in order.
That's okay.
Next item on our agenda is Senate File 36. We think this is going to go quickly. We hope, Senator Kunesh.
I will do my
here.
best.
There is an
I would
amendment
appreciate
here.
all of you doing your very best.
Senator Kunesh, tell us about your bill and why we're here.
Sure. This is Senate File 36. It's to create a missing and murdered Indigenous relatives reward account. And I think Senator Limmer is familiar with this. He supported it last year and had it in his omnibus bill. So we are back to create that. But before I go any further, I'd like to offer the A3 amendment.
Members, this is the first stop for the bill. This is an author's amendment. Senator Umu Verbatim, the co-author on the bill, moves adoption of the A3 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. Amendment's adopted. Senator Kunesh.
Perfect. So just to review the bill itself, it creates an account to fund information on missing and murdered Indigenous relatives, and it will be housed in the state treasury and, in the special revenue fund. And these dollars will be available for the Permanent Office of Missing and Murdered Indigenous Relatives to use for cold case, for case review, to use to support that office. It is a permanent office in our state government that we were able to create. And the idea around this is that entities, individuals, faith-based organizations, tribes, anyone would be able to deposit funds into this fund, and then the office would be able to use those as they see fit. And that's pretty much it in a simple explanation. I do have the Executive Director, Juliette Rudy, here, if you would be ready to hear some words from her as well.
Ms. Rudy, go right ahead. Thank you for being here. Give us just a couple of moments of your thoughts on this if you wish, or your availability to answer questions. That's fine, too.
Okay. Go ahead. Oh, Mr. Chair and members, my name is Juliette Rudy. I'm here on behalf of the Missing and Murdered Indigenous Relatives Office. I am the current director. I'm a tribal member of the Lower Sioux Indian community here in Minnesota. My experience in public safety spans almost 28 years. Research has found that Native people have been disproportionately impacted by violence in Minnesota and across the nation. Our office is currently providing support and resources for impacted Indigenous families and communities. This bill would be an added tool that will contribute to resolving MMIR cases and, most importantly, bring hope to Indigenous victims' families. The prospects of a reward fund for information on unsolved crimes has the propensity to increase the number of tips and calls received. In addition to being able to generate and renew interest on cold cases, there are multiple reasons why people would otherwise not come forward with information, ranging anywhere from being unaware and their information is valuable or relevant to potential informant not trusting law enforcement. A reward fund program provides public awareness and incentive. Most importantly, for crime victims and their families, reward fund programs are a beacon of hope when they have yet to see justice. Assistance of any caliber helps victims and their families know that every avenue is being pursued and that their case matters. The measure of success of a reward fund program will not be in how many rewards are paid out or even how much money is given. It will be based on the results of how many cases are closed, arrests are made, and crimes prevented directly because of information received due to monetary compensation. The MMIR vision is to reduce and end violence against all Indigenous relatives in Minnesota.
Thank you for your testimony. Any other members of the public wish to testify on this bill? I'm not seeing any. Committee discussion, any thoughts, questions, concerns? Senator Limmer.
Thank you, Mr. Chairman. Senator Kunesh, in comparison to last year's bill, is there any differences for the use of the funds that we would make available?
Senator Kunesh.
Senator Limmer, no, we have not changed the usage at all on how those dollars, those reward dollars could be used.
And, Mr. Chair, is the dollar amount different this year?
Senator Kunesh.
I believe we are using the same dollar amount as last year. It's $110,000.
Okay, that's all.
Thank you.
Any other questions or comments from members of the committee? Not seeing any. Senator Umer Verbaeten, you have a motion? This goes to state government.
Thank you, Mr. Chair. I move that Senate File 36 as amended be recommended to pass and refer to state and local government and veterans.
Seeing no further discussion, all those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Kunesh.
Thank you.
Senator Kunesh, we're going to do your other bill next.
Thank you.
You have a constitutional amendment relating to equality under the law.
I do indeed.
Pappas also has Senate File 47 involving a resolution memorializing the Congress. So we'll have both of you at the testifier table.
Thank you. And Mr. Chairman, with your permission, I think our testifiers could testify then on both bills rather than twice.
That would be very helpful.
Great.
Thank you. So, Senator Kunesh.
Thank you again, Mr. Chair. I have before you Senate File 37, which proposes an amendment to the Minnesota Constitution that states equality under the law shall not be abridged or denied by the state and its political subdivisions on account of race, color, creed, sex, sexual orientation, gender identity or expression, age, disability, ancestry, or natural origin. Members, without this ERA statement in our Constitution, we recognize that historically and regularly, women as well as men have had to fight long, expensive, and difficult legal battles in an effort to prove their rights are equal to those of other sex or gender. Every single one of us, no matter where we live in Minnesota, has the right to live free from violence and discrimination, to enjoy the highest attainable standard of physical and mental health, to be educated, to practice the religion of our choice, to love and marry who we choose, to own property, to vote, and to work in a profession of choice while earning equal wages with those in the same position. 80% of the people in the United States think that men and women are guaranteed equal rights in the U.S. and the Minnesota Constitution, but they're wrong. Members, I offer that this one sentence would make all the difference to ensure that all Minnesotans are guaranteed protections under the Minnesota Constitution. This bill, when passed, does not automatically add this statement into our Constitution. I want you to know that. But it puts the question to the voters of Minnesota. If Senate File 37 passes, when it passes, it will allow Minnesotans to decide if they want this statement of equality to be codified, putting an unquestionable protection for women and other marginalized gender directly into the Minnesota Constitution. According to a 2016 survey commissioned by the ERA Coalition, a whopping 94% of people in the United States would support an amendment enshrining gender equality into the Constitution. When the Equal Rights Amendment was passed by Congress in 1972, it was a culmination of a fight that had already lasted 4 decades, and obviously it is far from over. So this formal protection under the law will guarantee gender equality, which is not an anomaly. After learning about gender equality laws in other countries, 81% of the voters said they would support the ERA. And so members, with that, I ask for your full support in moving this constitutional amendment proposition forward. Thank you.
Thank you, Senator Kunesh. Senator Pappas.
Thank you, Mr. Chairman. So while Senator Kunesh's bill would put a question before the voters about putting the Equal Rights Amendment in the Minnesota Constitution, Senate File 47 is a resolution memorializing Congress to resolve that the requirements to ratify the Equal Rights Amendment have been met so that it could be in our national Constitution. Mr. Chairman, I'd like to just read a few sections from the resolution, but first I do have the A1 amendment to update it.
All right, so members, we have Senate File 47 before us. The A1 amendment is proposed or is moved by Senator Pappas. This is the first committee, so it's an author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment's adopted. Senator Pappas.
Thank you. So, Mr. Chairman, whereas
Sorry,
the
Senator
equal...
Pappas, Senator Limmer has a question. Should be in your
A1?
Should be in your packet, Senator Limmer.
Should be.
If not, we'll get another copy to you. Remember, this is Senate File 47. We're taking both Senate Files 37 and 47 before us at the same time.
Mr. Chairman, I could point it out for Senator Limmer.
Senator Limmer, do you have a manila envelope
I do.
among your packet there?
I have the amendment.
Okay. Members, included in your packet is a large manila folder that contains all of the information relating to Senate File 47.
All right.
Mr. Chairman.
Senator Pappas.
Thank you. So just a few excerpts from it. Whereas the Equal Rights Amendment was first passed by Congress in 1972 and was sent then to the states for ratification, whereas the ERA guarantees equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Whereas the adoption of the ERA will help to advance gender justice for women, girls, and gender-expansive individuals. Whereas the ERA authorizes Congress to enforce by appropriate legislation the provisions of the ERA. Whereas the ERA states that the amendment will take effect 2 years after the last constitutionally necessary state ratification occurs. Whereas on January 27, 2020, Virginia became the 38th and final state needed to ratify the ERA, which has now been ratified by the necessary 3/4 of states. Whereas the Archivist of the United States performs a statutory and ministerial role with respect to certifying the ratification of amendments to the United States Constitution, but as of this date, the Archivist has not certified the amendment. Whereas no time limit exists within the text of the proposed amendment that was ratified by more than 3/4 of the state. The states vote on the text, not the preamble. The preamble is merely advisory. Whereas women, girls, and access to health, wealth, and opportunity, and increasing incidences of poverty and violence. And whereas the ERA was first written by Alice Paul, the head of the National Women's Party, in order to guarantee that the rights affirmed by the United States Constitution are held equally by all citizens with regard to sex. And I believe that was around 100 years ago, 100 years ago. Whereas the ERA would provide a fundamental legal remedy on sex discrimination, would clarify the legal status of sex discrimination for the courts, whereas Minnesota ratified the ERA in 1973. I'm just going to skip over some stuff about the courts have not interpreted the 14th Amendment to protect against sex discrimination. And whereas in 1868, the 14th Amendment was added to the Constitution despite 2 states purporting to rescind their ratification. And be it resolved by the legislature, the state of Minnesota, that it urges the Congress of the United States to pass Resolution 25 and Senate Resolution 4, resolving that the requirements have been met to ratify the ERA, and it shall now be known as the 28th Amendment to the Constitution. So the rest of the resolution, members, is in your packets. But I think I chose the highlights.
Thank you, Senator Pappas. Are each of you senators prepared now to go forward to testimony?
Yes.
Then what we're going to do is we're going to call testifiers up to the table. And
Mr. Chairman, do you want us to remain or leave room for testifiers?
well, I think we should leave some room for the testifiers,
Okay,
if that's
we can
okay.
step
And
away.
then we'll be able to be a little more efficient about it. And I'm not sure, since we're sort of blending this process here, whether we're going to be in the order that I have listed here. So I'm just going to ask the first three who have come forward to tell me your names, and I can make sure, and then I'll know where to
Ann
start on my
Tracy, starting
list.
here. So,
I'm sorry, go ahead.
yes, thank you, Mr. Chair and members. My name is Ann Tracy, and I am here on behalf of Women's March Minnesota, ERA Minnesota. I'm with my mom. My daughter was here all morning. This is not my daughter. Sadly, she had to go to work. So but we are here to ask you to support the ERA.
Let me
Three generations.
apologize to your daughter. I know she was excited to be here, and I had anticipated getting to this earlier today. She probably got, in a sense, an unexpected civics lesson watching
She
the
did.
committee
She
do
did.
other work.
Always be learning.
So,
Always be learning.
But thank you, and I recognize that she was here and appreciated her being here as well.
Thank you.
Please go ahead, Ms. Tracy.
Mr. Chairman,
Whichever
members,
Ms. Tracy's going to speak.
my name is Elaine Tracy, and I am here on behalf of the Women's March Minnesota. I grew up in St. Paul in the 40s and the 50s. In fact, I grew up right across the street from this then non-existent building on 55 Sherburne. When I was in school, I wanted to be part of the patrol system. That didn't happen. I also wanted to be an altar server at my church. I thought for sure I was going to be selected because I knew the Latin phrases and responses better than any boy in the class. That didn't happen. I also would have enjoyed playing on a girls' sports team competitively. They were not available at that time. None of these dreams came true. By the time I graduated from the University of Minnesota, I had given up on my dreams to go to law school. Sadly, even my father thought that it was a waste of time and money for a girl to go to law school. I believe the possibility of achieving your dreams should be based on ability and not on gender, and I hope you do too.
Okay. Yeah, and go ahead.
So,
I was
Ms.
able to
Ann
do.
Tracy. I just have to say who's speaking so the record is clear.
Okay, Ann Tracy, yes,
Ms. Ann
thank you
Tracy,
again.
go ahead.
It's Ann Tracy here. I walked through a lot of the doors that my mom opened for me. When I was 20, I remember thinking, I'm pretty equal. I feel like we've done this. And then my first career job, I found out I was making considerably less money than my male counterparts. This is 30 years after the Equal Pay Act. Not that anyone needs to use the math on my age there. The ERA could have prevented that. But what the ERA can do as well is set a tone of respect. Recently, I was interviewed by a guy who wanted to hire me to write federal grants, do research, communications, and build a website. Or as he said, be a girl Friday. I have 20 plus years in telecom policy and 2 master's degrees, and he thinks that I can be a girl Friday. It's demeaning, and we need to change it. And laws can affect change, legal and set tones. I'll speak a little bit for my daughter, Anya O'Donnell. She is a full-time computer science teacher. She studied robotics in school. I want to make sure to get her sentence right because it's so, as she says, the grade schools where she works, with my students, she sees subtle ways that girls are turned off or turned away from robotics, many times in fear of having to face the patronization of their white peers. She has seen smart, talented girls treated like inadequate imposters for trying to have the same opportunities as boys. And even more worrisome than that is that she has a lot of friends that are gender expensive, transgender, gender expensive. And they're running into a lot of the roadblocks that my mom ran into. Sports opportunities are limited, even bathroom access can be difficult. You know, there is discrimination. What also happens then is, as my mom has talked about, and which as I've said, you internalize it. You know, not only is it opportunities lost, but you start to think less of yourself, and that's not right. We're not treated equally, we don't dream equally, and we need that to change, and I thank you for taking up this issue. Thank you.
Thank you, Ms. Tracy. So I'm going to ask you to go back to your seats. Okay. And are you Mr. Johnson? All right, so before you start, Mr. Johnson, I'm going to invite Trista Mata-Castillo and Professor Teresa Collett to come forward and take the seats that are at the testifier table. And then, Mr. Johnson, why don't you go ahead with your testimony? Just state your name and your position before you start. Thank you.
Thank you very much. Chair Latz, committee members, my name is Curtis Johnson, and I serve as the State Director for ERA Minnesota, and I'm here today to testify in favor of Senate File 37. Enshrining equal rights protections for all citizens has always been a bipartisan exercise. Currently, 27 states have adopted state constitutions or constitutional amendments that prohibit the denial of equal rights under state law based on sex. Amendments to a constitution can be contentious, but this one should not. James Madison did not want to write the Bill of Rights because, among other things, he thought the rights of citizens were, in his words, self-evident. History has shown us that what is self-evident to one person is not necessarily self-evident to all. What is self-evident is that all Minnesotans should be treated fairly, regardless of race, color, creed, sex, sexual orientation, gender, identity, or expression, age, disability, ancestry, or national origin. All means all. When people ask why I support the ERA, I usually say, it's simply the right thing to do, and it is. In addition, eliminating discrimination and ensuring equal rights can have a positive impact on the economy by increasing productivity, reducing healthcare costs, and promoting innovation. By adopting a state ERA, Minnesota could position itself as a leader in promoting gender equality and attract business and talent that value diversity and inclusion. The time is now. Lawmakers first introduced the ERA to Congress in 1923. It took almost 50 years before the amendment was passed by both chambers of Congress. And in the 100 years since the ERA was first introduced to Congress, 27 states have approved state-level ERAs and 38 have ratified the federal amendment. Dr. Martin Luther King once said that the time is always right to do what is right. And today the right thing is for this committee is to pass Senate File 37. And I thank you for your consideration.
Thank you, Mr. Johnson. Commissioner Mata-Castillo.
Yes, thank you, Mr. Chairman. Members of the committee, I'm Trista Matas-Castillo. I'm here today both as a woman veteran who has served in 3 branches of our military service, 16 years on active duty, and as a fellow elected official. I'm here to support the Equal Rights Amendment and putting it on the ballot for our community to vote on. Like all of you, I have taken an oath to protect and defend our Constitution, to support our Constitution of the United States and the state of Minnesota. And yet, despite the progress we've made in this country, there's still one fundamental right as a woman that we have not yet achieved: the right to equal protection under the law, regardless of gender. As a woman who has served in the military, I served in the National Guard, the United States Marine Corps, and the United States Navy, and 16 years of active duty. I saw firsthand the impact of gender discrimination. I've seen women denied promotions, overlooked for leadership roles, and I myself was subjected to sexual harassment and rape. And while we have made progress in recent years, we still have a long, long way to go. But the consequences of gender discriminations are not just personal. They have a significant impact on our communities. When people are not paid equally for their work, experience harassment because of their gender without recourse, or are passed over for promotions and are denied opportunities in places of enormous burden on our local governments. We must provide public programs to support their families. These costs fall disproportionately on women, especially women of color and those in low-income communities. Passing the Equal Rights Amendment would send a powerful message to women everywhere that they are valued and respected and valued members of our society. It would give them the legal protections they need to succeed in their careers, protect their families, and live their lives without fear of discrimination or violence. It would also save local government millions of dollars each year by reducing the need for public assistance programs. Ramsey County alone has calculated that the Equal Rights Amendment would save us more than $8 million annually. Therefore, I urge all of us to take action, add the Equal Rights Amendment to the ballot, and let us give the people the opportunity to vote and make their voices heard in support of this vital amendment. Let's come together and create a more just and equal society for all Americans now and for all the generations to come. Thank you, Mr. Chair.
Thank you, Madam Chair. I appreciate your being here. I'm going to ask Mr. Johnson and Chair Matta-Castillo to go ahead and return to your seats in the audience, and we will ask Joan Whitman and Betty Folliard to come forward.
Mr. Chair.
Okay, so Joan Whitman apparently has tested positive for COVID this morning. She is going to appear by Zoom. That leaves an empty chair up front, though, so we'll have Suzanne Wilhite come forward for that chair as well. Suzanne Wilhite to come forward and sit down. And then Professor Collett, welcome. Go ahead.
Thank you. Thank you, Mr. Chair. And I've got to say, this is the one time in committee I've been thrilled to hear you say be brief. As you can tell, I'm not intending to sound like Jean Harlow, but I am, I'm afraid. So I want to separate the two bills because my objections to them are separate and different. I've provided written testimony to the committee and provided the 30 copies of each that's required if you haven't filed it. I've also provided an electronic copy to the clerk of the committee.
Could you please either pull the mic closer to you or lean forward into it so that we can hear you?
I will, but I'm worried about breathing on it.
Well,
So, okay. Let me begin with Senate File 47. I believe that this bill is a solution that is simply untenable. The ERA, as the author admits, was not passed until 1972. In fact, multiple courts have found that the failure to ratify it within the initial 7 years requirement, an additional 2 years, 3-year extension by Congress, has rendered it moot. Even Justice Ginsburg, in talking about the bill, said that the deadline had passed. I would like to see a new beginning, she said. I'd like to start over. There's too much controversy about latecomers. Virginia, long after the deadline passed. Plus, a number of states have withdrawn their ratification. So if you count a latecomer on the plus side, how can you disregard states that have said, we've changed our minds? In addition to that, all 5 federal courts that have looked at this legislation, because of the advocacy across the country, have found that it has not been ratified. Most recently, on Monday, the Circuit Court of Appeals in the District of Columbia joined those courts. The courts are unanimous on this point. It simply is no longer viable, and it's no longer viable for good cause. It's no longer viable because we're simply not the same society we were 50 years ago. Mr. Chairman, I've added an Appendix A to my written testimony, which will show you a partial listing of the changes in law, both in case law and in federal statutes, since 1972 when it was first passed. Culturally, today, there are more women med students and more women law students than there are men. In addition to that, women's activity as far as entrepreneurial activity has exploded. Women of color in particular have advanced significantly in this. In fact, the increase in business of women of color was spectacular. In 20 years, businesses owned by women of color grew by a rate of 467%. I provided that data in the written testimony. Now let me turn to Senate File 37. Senator Kunesh suggested that 70 to 80% think that the federal and state constitution protects against sex discrimination, but she said they're wrong. That's simply not an accurate statement. The United States Supreme Court, for many, many years now, has recognized sex discrimination as a basis to protect and strike down laws when they, in fact, impinge on the rights of women. Most recently, in 1995, we have the United States versus Virginia, in which case VMI was opened up to women students in that case. There are existing constitutional protections in the state of Minnesota as well. Article 1, Section 2 provides explicit protection. No member of this state shall be disenfranchised or deprived of any rights or privileges secured to any citizen thereof, unless the law of the land or the judgment of his peers. In that instance, the court has, in Minnesota Supreme Court and courts of appeals have interpreted that to encompass discrimination based on sex. We also have the Minnesota Human Rights Act, which is codified in Chapter 363A, which is extensive and provides multiple protections. Most recently, in 2021, the Court of Appeals affirmed that and discussed the stages of scrutiny. More fundamentally, my objection to the state proposed ERA is that it's a Trojan horse for abortion on demand. The strategy has proven successful in many states adopting state-level ERAs. The New Mexico Supreme Court notably ruled that a state policy limiting public funding of abortion violated the same ERAs. In the discussions regarding Senate File 70, we've heard time and time again about the concerns about protecting abortion in this state. This will do nothing to go beyond Doe versus Gomez in that case. Finally, I would say that the proposed ERA will result in complex constitutional questions. If enacted, Senate File 37 will place religious protections afforded by Article 1, Section 16 of the Minnesota Constitution in danger. In fact, one of the previous testifiers specifically used the example of being an altar server. Of course, religious congregations and communities should be free to choose who will serve them in some sort of ministerial capacity. And yet, even by that testimony, she evidences the sort of protests we can expect through the courts and litigation. It will also affect the conscience rights of individuals in the state who believe in a traditional understanding of sexual diversity. In this case, we can look to the Anderson versus Grand CVA pharmacy case, where a pharmacist succeeded in persuading a jury that his refusal to provide emergency contraception did not violate sex discrimination. When I look at the Justice website, it says it's on appeal, but my efforts to find that appeal on the Court of Appeals website, I've been unable to discover it. So that case may have been settled. I simply don't know. Finally, I would note that the reference to a prior testifier that she wanted to play sports competitively, this, in fact, has been one of the big problems throughout the country. If we pass this ERA, we can expect demands that boys compete in girls' sports. We can expect gender-neutral bathrooms. We can expect housing to be afforded on a gender-neutral basis, so dormitories will not be able to be sex segregated. I think this bill is a very bad bill, and to the extent that they're worried about sex discrimination in the Constitution, we already have it in Article 1, Section 2. Thank you.
Thank you, Professor, for your testimony. We're going to go to Joan Whitman, who we have online, I believe. Ms. Whitman, welcome to the Judiciary Committee. You need to unmute. Ms. Whitman, we cannot hear you. You need to unmute your screen so when you speak, we can hear you. There we go. You need to unmute.
Chair Latz and members of the committee, I'm Joan Whitman. I live in St. Paul. Thank you for the opportunity to tell my equity story remotely. I've waited a very long time for this moment, so I don't want COVID to stop me from testifying to you today. A justice issue that I care deeply about and that touches me personally is the Equal Rights Amendment. My gender equity story covers a span of over 80 years that addresses almost a lifelong interest and commitment for enactment of the Equal Rights Amendment, commonly known as the ERA. The original wording of the ERA was just 14 words. Equality under the law shall not be abridged or denied on account of gender. The 20 2023, 24 bills, both national and state, have added additional words to name those who are included and protected. I grew up on a farm in the 30s and 40s between two brothers. I remember when I was around 8 years old, one of our cows was about to give birth, and I told my dad I wanted to see the baby calf being born. I was told that's not appropriate for girls, but it was okay for my brother, who was 10. Going to Catholic grade school, I wanted to be an altar server. This was in the early 40s. I knew the Latin responses better than my older brother, but I couldn't be a server because I was a girl. After college, I was a primary teacher, and after I married, this was in the late 50s, and was pregnant, I couldn't teach, not because I wasn't qualified, but because of rules that pregnant women were physically unfit. But the unsaid belief was that pregnant women would be a scandal to the students. If you were pregnant and didn't disclose, you risked losing your teaching license. Male teachers were paid a higher salary. Another inequity of those times was I could not get a credit card or a loan in my own name. When I was ready to buy a car, my dad had to be the signer. When Wayne, my husband, and I bought our first house, only Wayne's name was listed as owner. These are just some of my personal experiences for why I believe we still so need the ERA. I'm sure you could add to this list. Today, many of the experiences I had in those earlier years have been addressed, but still, the 2020 Gender Pay Gap Report shows income disparities where women earn 82% of what men make for doing the same work. With our current Supreme Court and with their reversal after 50 years of the Dobbs Amendment, I fear women's rights are again endangered. Opponents will argue that women are already protected by law. Yes, that's somewhat true, but laws can easily be changed. It's much more difficult to change an amendment. We still have work to do. Women are half the world's population, but we do not have equal rights. I was 92, February 23rd. My time is running out. My dream before I leave this planet is to see the ERA included in our own Minnesota Constitution and for it to be enacted in our U.S. Constitution. Yes. Let's get a question for Minnesota voters for or against including the Equal Rights Amendment in our Minnesota Constitution on the November 2024 ballot. Thank you for listening. I ask for your support of Senate File 37.
Thank you for your testimony, Ms. Whitman, and best wishes for good health as well.
Thank you.
Appreciate your being here. Former Representative Betty Folliard, welcome to the Judiciary Committee.
Thank you, Mr. Chair. Members of the committee, happy Women's History Month. My name is Betty Folliard. I am the founder of ERA Minnesota, and this is I'm going to be speaking to the federal ERA, which is SF 47. This is a simple resolution to Congress encouraging our leaders to enact the now fully ratified Equal Rights Amendment, the ERA. Minnesota ratified the Equal Rights Amendment in 1973, the federal Equal Rights Amendment. And the Minnesota Senate passed a similar resolution in 2016 by an overwhelmingly bipartisan vote of 56-6. The essential concept of this resolution is to provide equal treatment under the law for all in this country. What will the ERA do? The ERA will remove ambiguity in the law to provide consistency in our court system against sex discrimination. Currently, there are a patchwork of laws across the country regarding equality. The ERA will ensure constitutional consistency regardless of where you travel, state to state. The ERA will provide a constitutional safeguard against rollbacks on the gains that girls, women, and LGBTQIA+ individuals have made over the last centuries. And it will bring the United States in line with the rest of the world. Currently, 85% of UN member states have a provision in their constitutions that addresses gender equality, and a further 115 of them have a provision that prohibits discrimination on the basis of sex. So why do we still need the ERA? Because women make on average 82 cents for the man's dollar, with much, much larger inequities for Black, Indigenous, Latina, Asian women, and women of color. Because twice as many women as men over the age of 65 live in poverty. Because 2/3 of tipped workers and 2/3 of minimum wage earners are women. Because less than 1% of rapes will ever lead to a felony conviction. Because we're still fighting the battle for voting rights for all, because 1 in 5 college women will experience sexual assault, because women still get fired for being pregnant, because child care can cost more than college, because some bosses deny workers birth control coverage, because we're one of only 3 industrialized countries in the world that still don't have any paid maternity leave, because women fight and die for their country and they still don't have equal rights, and because women don't want to wait another 246 years for equality. That's why. So girls and women comprise over half the population of the United States. The ERA will guarantee them equality so that they cannot be treated as lesser than. The ERA will embed the fundamental guarantee that the U.S. Constitution guarantee in the U.S. Constitution for all people, ensuring that individuals, regardless of sex, are treated equally under the law. I respectfully request your yes vote on SF 47 and SF 37, which I'm happy to answer questions about. And I thank you for your time.
Thank you, Representative Folliard. Suzanne Wilhite.
Mr. Chair and members, my name is Suzanne Wilhite, and I'm here as president of ERA Minnesota, and I speak on behalf of the Equal Rights Amendment Minnesota organization. ERA Minnesota supports both Senate File 37 and 47. 37 has new inclusive language, so it's important that everyone reads that. And SF 47 is a resolution to Congress to resolve that the ERA is the 28th Amendment to the U.S. Constitution. This resolution is timely and important because the U.S. Senate Judiciary Committee held a hearing on the federal ERA earlier this week, February 28th. And they discussed the need for the Equal Rights Amendment that continues, and they plan a floor vote by April of this year, 2023. The ERA is still alive at the federal level. It is not dead. And legal scholars have agreed that Congress put a timeline on the amendment, and they agree that they can take it off. So we have passed twice in the U.S. House a rescission of the timeline, and the Senate is working on that very issue. It has a bipartisan history, was first introduced by the Republican Party in 1930s, and later supported by the Democratic Party. The U.S. Constitution is a proclamation of our nation's fundamental values and human rights, and needs to be amended to declare equal legal rights for we the people and actually include all the people. Currently, the U.S. Constitution does not guarantee equal legal rights for all people, and it does not explicitly prohibit discrimination on the basis of sex. Enacting the ERA would provide equality of rights for all people under the law. We need the ERA, as Betty mentioned, to ensure equal pay for equal work, fair health care coverage, protection from sexual violence, and workplace discrimination. Sex discrimination cases have gone all the way to the U.S. Supreme Court without remedy. Even Justice Antonin Scalia stated in 2011 that, quote, certainly the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It doesn't. Nobody ever thought that's what it meant. Nobody ever voted for that. Well, that's funny, because women weren't allowed to vote until the 19th Amendment in 1920. And in 1923, they introduced the ERA. Now it is 2023. That is 100 years for this amendment. 234 years since our U.S. Constitution was adopted in 1789. 100 years, 200 years, it's far too long to wait for equality for all people. Equality is not pie and it's not pizza. It does not mean that some people lose rights when others get equal rights. Equal means equal. ERA Minnesota supports Senate File 37 and Senate File 47. Equal rights is a foundational and long overdue right for all people. Thank you, and I request that you vote yes for both of these bills.
Thank you, Ms. Wilhite. Appreciate your testimony today. I'm going to ask the two testifiers to return to your seats in the audience, and we'll invite our two chief authors to return to the testifier table. All right, we will now open up the floor to committee members. Senator Umu Verbatim.
Thank you, Mr. Chair. Thank you, Senators Pappas and Kunesh, for bringing forward the bill. I just wanted to say how excited I was to see my commissioner, Matis Castillo, here, and Curtis Johnson when he's not busy serving as the ERA state director, serves our kiddos in Roseville on the school board. So thank you so much for your work on this issue. I think former Representative Folliard said it so well with that list of all the things we continue to fight for. It's not over yet, and we absolutely need this. So thank you all for your great work.
Senator Westland.
Thank you, Mr. Chair, and thank you to my colleagues, Senator Pappas and Senator Kunesh, for bringing these bills forward. We are long past time for passing the federal ERA and for adding an equal rights amendment to our own Constitution. You know, saying that we have somehow divested ourselves of discrimination, that we have become a society of equals around gender and gender identity issues is a little bit like saying we became a post-racial society simply because we elected Barack Obama. And actually what we saw after the election of Barack Obama was an enormous backlash. And we are feeling that backlash as well when it comes to the rights of women and for those who are members of our LGBTQ community. Now, my understanding of our values as a state, my understanding of our values as a nation, is that no person should experience discrimination regardless of their identity, nation of origin, religion, race, and so forth. And the problem that we have in particular with our federal Constitution is that we have different standards of review under the Equal Protection Clause. So when women have to bring forward discrimination or other types of legal actions, those actions aren't subject to strict scrutiny. They're intermediate, and the case referenced earlier, U.S. versus Virginia VMI, Justice Ginsburg actually came up with a little bit different, a slightly higher standard of review. Women aren't a suspect class. We aren't entitled to strict scrutiny under the federal Constitution. And it is time, long past time, that we change that. So I am going to encourage every member of this committee to vote yes on these two bills, to affirm the fundamental notion that every person should have the opportunity to live in our society, in our communities, in our neighborhoods without experiencing discrimination, that every person will have the opportunity to excel and exceed in their lives without impediment. Thank you.
You know, I'm just going to add a note that I'll be doing this not only for my spouse and my daughters and for subsequent generations, but, you know, I just heard a story on NPR last week about some MIT professors in the sciences and how they thought they'd made it through the door and that was it. They got hired as professors. And then when they got there, once they started looking around a little bit, they didn't have quite the same opportunities. And they felt a bit isolated until one day they decided to sit down to talk together and realized they had each experienced some of the same things. They had smaller labs. They weren't getting as many invitations to be co-authors on professional papers and so on. And so they banded together, and one of them actually went into the labs, being science professors, being scientists, with a tape measure, and measured the square footage of the labs, of the storage rooms, of everything in the building, and was able to demonstrate unequivocally to the authorities, to the leadership at the institution, that the female faculty members were not being treated the same as the male faculty members. And so on the story, they had the professor that kind of led this effort, and they had the author of a book about them as well. So the book, I think, is just recently out, which is why they were in the media on this. A lot of people blazing trails, and I appreciate all the work that's gone before us before we got here today. This is a special day, and I encourage members to vote in support of this. Senator Carlson.
Thank you, Mr. Chair, and I want to add to your experiences and your anecdote. I have a daughter who is an attorney in Los Angeles, and she has told me many times of some of the discrimination issues, and in fact, it happened exactly as you mentioned. It isn't until they get together and they talk a bit about who has gotten promoted to partner, who has not gotten promoted to partner, those kinds of things, and they're still happening. One thing that I would agree with the opposition testimony in, that we have a different culture now. We certainly do, because right now the culture is going in reverse. And we have state governors who are promoting the discrimination against transgender and non-traditional people, and to a degree that is making them into criminals. Yet, you can go to Google and type in Rudy Giuliani motorboat, and you'll get a picture and a video of Rudy Giuliani dressed up as a woman and doing what's called a motorboat on Donald Trump. So that's where we're going, is we're going backwards. We're forgetting what has happened by the people that are right now fighting for discrimination, because they used to be discriminating. So I think, and in favor of my 3 sisters, 2 now, who were single, my daughter, my 3 nieces, my 3 sisters-in-law, my mom, women's issues are survival for me. So we need to get this done. It is very important. So thank you, Senator Kunesh and Senator Pappas, for getting this going, and thank you, Mr. Chair, for hearing it.
Any other discussion from members of the committee? Senator Cruin.
Thank you, Mr. Chair. Senator Carlson's point, I don't want to go backwards either, but I feel that that's exactly what this ERA resolution does. It asks us to go backwards to a period of time when I wasn't even alive. Despite all the gray hair on my head, this all happened during an era I don't remember, wasn't alive to experience. So I just have some concerns about this, and Mr. Chair, if I may, if I could limit my queries to Senate File 47 and then come back later for the next bill after everybody's done, I would appreciate that if that's okay.
Yeah, that's fine, Senator Kroon. Go ahead.
Thank you, Mr. Chair. The biggest concern I have, I mean, over this Senate File 47, this resolution, is it seems like Minnesota did adopt the ERA. So we're not being asked to do that. That's already been done. So this seems like a purely symbolic resolution having to do with whether or not the deadline is passed. And so to me, this is a constitutional question as I size it up. The original ERA had a 7-year deadline on it, which was not met. I understand Congress has attempted several times to extend that deadline, which brings us to 2023. But maybe somebody can help me out, because as I looked into this, it appears the United States Supreme Court has already issued a ruling on this that Congress may not extend the deadline. And so I'm just kind of sitting here kind of confused as to what exactly we're doing. But if somebody has some information I'm not aware of, I'm happy to hear why this isn't a moot issue. Thank you.
Thank you, Mr.
Senator Pappas.
Thank you, Mr. Chairman. I did watch parts of the February 28th hearing in Congress where they were deciding whether they were going to vote to extend the deadline. There's nothing preventing Congress from doing that. But I will just say a little preamble to that. While I was watching it, 2 constitutional scholars were disagreeing as to whether the deadline was kind of official, if you will, because one said because the deadline was in the preamble, it was just advisory, and because it wasn't in the text of the actual amendment. So I think there is some constitutional scholar disagreement on that. But regardless, if there is some uncertainty about whether the deadline can be whether the 3 states that have ratified since the deadline are legitimate or not, that was the purpose of the hearing in Congress right now. So the resolution is really memorializing Congress to go ahead with whatever process they need to go through to officially certify that the deadline has been met, to tell the archivist to go ahead and publish the resolution, the amendment, so it becomes the official 28th Amendment of the Constitution. So you may argue it's symbolic, but I think the whole point of asking Congress to do things is because we in the state want them to do it.
Senator Kroon.
Thank you, Mr. Chair. If Congress wanted to move forward, Congress could, if they decided in its collective wisdom to do that, they certainly could do that. I don't know what this resolution urging them to do it accomplishes it, and that's where my comment comes in about why it's, to me, 100% symbolic, because Congress can pass extensions of the deadline if they want, and they have done that. That doesn't make it legal. If the Supreme Court disagrees that and says they don't have the right to do that, they can pass all the extensions they want, and it's meaningless. But even more to the point, the Minnesota legislature urging Congress to do something that is squarely within their purview seems to be a symbolic gesture. So that's where my comment comes from. But I'm looking at the 1981 case, Idaho versus Freeman, where the court specifically says, the court further declares that the majority action of Congress in attempting to extend the period for ratification of the 27th Amendment is void and of no effect. And I believe everybody at that time believed it was past the deadline, including the U.S. Solicitor General. That was, again, in Carmen versus Idaho in 1982, this was all rendered moot because everybody agreed the deadline had passed. So I'm looking at 2 Supreme Court cases from after that 7-year deadline had passed, and I'm looking at all this and saying this is all moot, that the deadline has passed, and Congress may be doing some things and extending the deadline once again, but that doesn't mean they can do it. I mean, it's still an unconstitutional resolution by Congress. So to me, this is a moot issue, and if we're going to want to pass an ERA, it seems like we should start over and do it the right way so that we don't have all the ensuing litigation and all the confusion, and just start over. And if the will of the people is so strong to do it, it shouldn't be, probably be a lighter lift than trying to do it this way. So those are my comments on SF 47. Thank you.
Mr. Chairman, I've called up a
Senator
friend, ERA expert, Betty Folliard.
Representative Folliard.
Thank you, Mr. Chair and Representative. Congress has the power to extend the deadline, to eliminate the deadline, or they can do whatever they want with it. And right now, the court actually kicked it back to Congress. That the Constitution firmly says that Congress has the power to decide about amendments, and that's what they're doing. So the last 2 biennia, the U.S. House passed similar language to the bill that this resolution points to. This resolution is very fresh because it's pointing to SJ Res 4 and HJ Res 25. And right now, as I say, in the last 2 biennia, the U.S. House passed similar resolutions, and this year the majority leader of the U.S. Senate has said that it is his intention to take up a vote on the Senate floor for the first time in 40-odd years to pass legislation that will remove that deadline to essentially enact the ERA. And when I say deadline, I mean the extra textual time limit, the arbitrary deadline that was a politically motivated process. When you only give women's rights 10 years to pass in America, there's something wrong.
I guess I would only add that all resolutions are symbolic. That's the very
true.
definition of what a resolution is, yet we have
Yes.
an official process in the Minnesota Senate to pass resolutions, and we can entreat Congress to do something, ask them to do it. It's the policy of the state to make that request if we have the majority willing to do that. But the other thing I'll say is that we've learned in the last year that U.S. Supreme Court precedent is not necessarily always applied. So whatever we want to say now about past U.S. Supreme Court decisions, we have a new court, and they might look at things a little bit differently.
Yeah, Mr. Chair, if I may just
Representative Folliard.
thank you, Mr. Chair and Representative. Symbols matter. The ring on your finger matters. And the flag that people can fight and die for matter. And resolutions from the state of Minnesota to the U.S. Congress matter.
Senator Kroon, follow-up.
Thank you, Mr. Chair. I agree in some sense all resolutions are symbolic, but not all resolutions seek to resolve to do something that in my view is unconstitutional. And so if the court has already said that Congress may not extend the deadline, then that is what makes this purely symbolic in a way that other resolutions are not symbolic. And the testifier said that the court has since kicked it back to Congress. I'd be happy to get a citation from you, because that's, and I could very well be missing that case. And so if somebody wants to email me a new court decision since 1982 where the Supreme Court has overruled itself and said this is squarely within Congress's purview, I'm happy to look at that case. Either way, it's Congress's decision. Even if that is the case, they'll do what they're going to do. But in my view, and even if the Supreme Court has reversed itself or does reverse itself at some future date, and if it does reverse itself at some future date, then I think this resolution would be much more ripe for this legislature to act on it. But if they have reversed it at some past date that I'm not aware of, then I nevertheless think it's a better idea to start this process over. Because most of the country was not even involved in this in any way when this first came up. I mean, probably half the country wasn't even alive. And so to me, if we're going to do this, let's do it the right way, start over, get consensus, and when it gets through and when we're not going to have a bunch of litigation clouding the issues. So either way, those are my concerns on this resolution. Thank you.
Any other questions or comments from members of the committee? I know Senator Kroon will return to you because you wanted to reserve the right to follow up on Senate File 47. Before then, Senator Limmer.
Thank you, Mr. Chairman. First, I have to make notice that Senator Kroon was not born in 1972, and that's making me feel really old. Someone agreed?
All those in favor, say aye.
Hey. Wow.
Senator Limmer.
Thank you. In looking at this provision, I'm going to focus my comments for the moment on Senate File 47. I've voted for similar proposals before, and I've done a lot of reading and research. This particular bill before us, or resolution, triggered a little bit more reading from a few years ago. But Senator Pappas, I wanted to just get some clarification on the language in the resolution. The reference, apparently there's been different varieties of ERA language around the states. Your focus is still on the 1972 version?
Is that a question?
Yes.
Yes.
Senator
Mr.
Pappas.
Chairman, yes, because changing the language would require going back and having additional ratifications. So, yes, the original language.
I'm getting a
Senator
little.
Limmer.
Thank you, Mr. Chairman. I'm getting a little confused from my understanding of the ERA language before compared with what you have now. We're on lines 120. After listening to the discussion by Senator Kroon, where it states no time limit exists. And there seems to be a rather robust history from Congress, statements from the House Majority Leader, Democrat House Majority Leader in 1983, referencing the 1972 area was dead by proposing that same ERA language they suggested to be sent out to the states again. And I hope you can understand my
Yeah, Mr.
confusion on
Chairman,
this,
I can.
because it seems like it's got quite a noted history going through federal courts, U.S. Supreme Court's overturning a previous one, saying that the issue was now moot, and now are we in the deadline, or is there a deadline? Apparently, the resolution says there is none, and yet on the next page it says that Minnesota ratified the ERA in 1973.
Senator Pappas.
Thank you, Mr. Chairman. It's a little technical between what the constitutional lawyers have been discussing. It's what I mentioned earlier, is that in some amendments, there is a timeline within the text of the amendment, and some it's within the preamble to the amendment. And in the ERA situation, it was in the preamble, and the preamble has been interpreted as advisory. So the preamble said it's advisory that you pass this within 7 years, and then later on, Congress extended that another 3 years. So that's all this is saying, that it's in the text of the preamble that there be a deadline.
You know, I'm going to confess I'm finding a lot of this discussion kind of moot, because we're not the decision makers with regard to constitutionality.
Right.
That chip will fall if and when it ever falls. And, you know, we've never really used constitutionality as a test to decide whether or not we'd pass a bill here. We would pass it if we thought the policy was appropriate. Some of us might vote against something because we think it's not constitutional, but ultimately it's the courts that make that decision.
Mm-hmm. Right.
We've covered a lot of territory here just on that one topic. Are there any other areas of discussion with regard to these bills before us? Senator Limmer?
Thank you, Mr. Chairman. In continuing the discussion on Senate File 47, there has been a concern by those who have a perspective of being pro-life that this would affect pro-life court cases in the future if this became law. Can you explain that? Is there a concern about that in your mind, or is there not?
Senator Pappas.
Mr. Chairman, Senator Limmer, excuse me, I really don't know. And I think we don't know. I think that it does say that women need equal access to health care in a kind of in a broad sense. But how it would impact the abortion situation, I'm not aware of how it would.
Well,
Mr. Chair, I could answer that.
Representative Folliard.
Mr. Chair and Senator Limmer, the abortion issue has been, in Minnesota, that's settled law. And it was settled law both through the Doe versus Gomez issue, and plus this year, the legislature in its wisdom has passed legislation to codify Roe v. Wade. And so it's kind of not on the table at the moment. One thing I can say about, and this goes to both bills again, the Equal Rights Amendment in state constitutions has never expanded abortion access. It has been used to protect the rights that women and people with uteruses have gained.
Mr. Chairman.
Senator Limmer.
Ms. Folliard, you may be correct in stating that this area of law is settled in Minnesota
Right.
for now. But passing this resolution to encourage Congress to establish the 28th Amendment has a far greater impact across the entire nation, not just Minnesota. So that's why I raise this question. I think the history is clear, and in the history that I'm reading, it says the leading pro-abortion groups, including NARAL, ACLU, Planned Parenthood, have strongly urged state courts to construe state ERAs containing language virtually identical to the language of the 1972 federal ERA proposal, the one that's right before us now, to invalidate laws that treat abortion differently from other medical procedures, including laws restricting tax funding of abortion and laws requiring parental notification or consent for minors. So the ERA, the 1972 ERA language has been used by those groups in court argument and using the very ERA proposal that we're talking about today. Isn't that correct?
Representative Folliard.
Mr. Chair and Senator Limmer, I assume because you have the information in front of you that it is correct. And again, you know, there are two, as one Supreme Court justice once said to me, there are always two sides to every argument. And you know, let the chips will fall where they may as far as the issue of abortion goes. But here in Minnesota, certainly it is settled law.
Mr. Chairman,
Senator Limmer.
I'm hoping that we could come to some type of agreement. And I don't know if that's possible or not. I'd like to introduce the A3 amendment on the Senate File 47 resolution, Mr. Chairman.
Members, to Senate File 47, Senator Limmer introduces the A3 amendment. The staff will distribute it to the members of the committee and to the public.
And to the author.
I have one.
No, bring me the amendment right away. Here comes Nicole.
I'll wait until it gets passed out, Mr. Chairman.
Senator Limmer, to your amendment.
Thank you, Mr. Chairman. The A3 amendment makes reference to, and I'll read it, it's easier to read than explain, and to establish as part of the related legislative record that the Equal Rights Amendment must not be construed to grant, secure, or deny any right relating to abortion or the funding of abortion. Essentially, it's neutral. And if this was added on, I could vote for it. If it's not, I have to claim a conscientious objection because, quite honestly, the current ERA language that's before us without this amendment would cause me to vote and cause the death of an innocent human life. And from a conscientious objection, I can't and will not support that. The language of the ERA with this would allow me to vote for the ERA. And as I have said before, I voted for the ERA once before. But after studying the impact of that language, I can't go any further. So I'm asking the committee to consider this A3 amendment, and I ask for a roll call, Mr. Chairman.
The chief authors of the bill, Senator Pappas.
Thank you, Mr. Chairman. I appreciate and respect Senator Limmer's feelings about this, but I do think that it's inappropriate to put this in the resolution because I don't think this issue is really relevant right now to the ERA.
Senator Westland.
Mr. Chair, the other thing I would say is that what we're talking about is the ERA has passed in a certain form that does not include this language. So in essence, by adding that language, it seems to me we're attempting to change what has already been ratified by the states, and I don't believe we have the authority to do that. So that's my first concern with this. Literally, the language of the amendment would have to be changed in order for this to be binding in any way. And I oppose it anyway because I think that it sort of defeats the purpose of the Equal Rights Amendment, which is to say that women are full, complete, grown folks that get to make decisions about our bodies, that we get to make decisions about when and if to have children. I will respectfully push back against, I've heard the words abortion on demand again, and that's not a thing either. But certainly anything, we already have a federal restriction on abortion. It's already happened. So I would oppose this for those reasons, and I would ask committee members to vote no.
Mr. Chairman.
Senator Limmer.
Thank you, Mr. Chairman. And I want to thank everyone for a respectful conversation. A resolution is giving advice to Congress. And on lines 3, 11, and 12, that's the further resolved. It kind of brings the resolution to a close that the Secretary of State of Minnesota is directed to prepare copies of this memorial and transmit them to the United States President, Secretary, Senate, House officials. This is basically an official memorandum to Congress. And if we did add the A3 amendment, it might show that Minnesota's rethinking this a little bit. I think it's wholly appropriate since, when was it passed? 1973? I would think that there would be plenty of years past giving the people of Minnesota and representatives and senators the opportunity to think about this a little deeper, and perhaps a little language change might provide a unified effort and language to Congress. So that's why I present it. I'm thanking everyone for a respectful conversation. Senator Westland, I didn't ever say abortion on demand. Oh, someone else did, okay. And so we'll put it up flagpole and see what happens. Thank you.
Seeing Senator Westland?
Mr. Chairman, Senator Limmer, I apologize I apologize that my words were not as respectful as you might have wanted them to be. It's not my intention to be disrespectful to anyone who appears before this committee. I am passionate. Sometimes that expresses itself in ways that I can imagine may absolutely feel disrespectful, and I apologize to you, Senator Limmer.
Mr. Chairman.
Senator Limmer.
Mr. Chairman, Bonnie, there is no reason to apologize to me. Passion is the root of politics, and it should always be. You don't need to apologize to me for that at all.
Seeing no further discussion on the A3 amendment, Senator Limmer moves the adoption of the A3 amendment. All those in favor
No,
say
roll
aye.
call, I said. I had asked for a roll call.
Oh, I'm sorry, did you ask for a roll call? Then there will be a roll call. The clerk will take the roll.
Senator Latz? Chair
No.
Latz, sorry.
No.
Senator Umuver Baton?
No.
Senator Limmer?
Yes.
Senator Carlson?
No.
Senator Eichhorn? Senator Howe? Senator Kroon?
Yes.
Senator Pappas?
No.
Senator Seeberger?
No.
Senator Westland?
No.
Senator Eichhorn? Senator Howe?
There being 2 in favor and 6 opposed, the amendment is not adopted. Senator Kroon, did you wish for us to return to you with regard to Senate File 37?
Thank you, Mr. Chair. Real briefly, I do feel I need to respond. I believe, Mr. Chair, you made some comment, and I'm not going to belabor the point on Senate File 47 and about whether or not the deadline has passed. I'm not going to revisit that, but you made a comment of something to the effect of constitutionality is not usually a basis for consideration in this committee, and I guess that offends my sensibilities because, I took an oath of office and to defend the constitutions of the United States and Minnesota when I took this office, and to me, evaluating the constitutionality of a bill is a prerequisite before I even consider the merits of it. I do that on literally every single bill I consider, and I believe that to be a part of my job. So that I just wanted to explain to the committee where I'm coming from and why I was scrutinizing that clause the way I was.
Yeah, Senator Kroon, I appreciate your comments, and as soon as I said what I said, I thought, well, that's not exactly the position I've taken on every bill. So I have encouraged people not to vote for bills because I thought they were unconstitutional. On the other hand, it seems to me if there's some questionable constitutionality, but I support the policy, I think it's worth considering voting for the bill. And in particular here, what we have is a resolution to Congress. So it's not as if we are proposing to put anything into statute that's going to be reviewed by court. It's basically expressing a sense of the people of Minnesota by and through our legislative leaders that we want Congress to do something. And I guess I think there's doubt, perhaps, as to the constitutionality of what is happening in Congress right now or what we're asking them to do. But I don't think there's any constitutional question about whether we have a right to ask them to do something. So I would encourage members to vote yes on this.
Mr. Chair.
Senator Kroon.
And that's a fair point. And every legislator is going to have to kind of draw their own line on their comfort level on that. And I appreciate your follow-up remarks on that. And if I may move on to SF 37.
Please, yes. And I'm just, and I,
All
yes,
right,
go ahead, Senator Kroon.
I'll try to be brief. Looking at the bill, I had some questions about definitions. I'll start with, and I don't know, maybe this would I assume would go to Senator Kunesh, I guess. My question would be, the term ancestry in line 1.10, does that have a specific definition? It's not a usual term that I deal with or that I've heard of in statute, and I know there's maybe a couple places where that comes up in statute, but I'm just wondering if there's a definition that specifically that you had in mind in using that term.
Senator Kunesh.
Thank you, Mr. Chair. I'm afraid I don't have a definition for you at this time, but I can get that to you.
Senator Kroon.
Thank you, Mr. Chair. I believe that my brief, there could be one in Chapter 15 and one in 325D. I don't know if there's any place else, but I'm not exactly sure what that, do you have, aside from a specific definition, do you have generally what you mean by that term in this bill?
Senator Kunesh.
Certainly. There have been both legally and societally issues around questioning or using a person's ancestry that has allowed inequity both in housing, in jobs, in wages, and historically this has been true. And so we wanted to add that into that so that those kind of prejudices will not be, would be seen that this it equates into the equality definition.
Senator Kroon.
Thank you, Mr. Chair. I guess what I'm trying to get at here, I guess, in listening to your response, and I'm just wondering, not making a statement, I'm just wondering if there's redundancy here. Do you think that ancestry could mean something aside that, you know, wouldn't apply to race, color, creed, sex, sexual orientation, gender identity or expression, age or disability, or would it be tied into those things? Or how would ancestry be its own kind of separate category? I guess that's what I'm getting at.
Senator Kunesh.
So ancestry, ancestry is unique in that maybe some of these things, such as race or creed, or those sort of things, tie into or are part of an ancestry, but not necessarily separately. And so in order to address those ancestry examples, that we would include ancestry in this definition.
Senator Kroon.
Thank you, Mr. Chair. Thank you for that response, Senator Kunesh. I believe it was in your opening remarks, you mentioned, along with many other things, that how we value the free exercise of religion in this state. I don't want to, I'm paraphrasing, I don't remember exactly what you said, but there was a reference to the free expression of religion, I do believe, in your opening remarks, yet Senate File number 37 doesn't reference religion, and I'm assuming, and you can correct me if I'm wrong, that that's because in our state constitution, Article 1, Section 16 already includes the freedom to exercise religion. Is that kind of am I correct, and that's the reason why it's not included in Senate File number 37?
Senator Kunesh.
Senator Kroon, as you look into this, the use of the word creed is a synonym for religion, and so we've used the word creed.
Senator Kroon.
Thank you, Mr. Chair. I'm not sure creed is synonymous with religion, but I will note that, you know, religion is already in our state constitution. So I'm assuming that I would think that the basic construction, that if this were to pass and go to the voters and be enshrined into our constitution, that the effect of this new constitutional clause would not trump the effect of an existing constitutional clause, such as the constitutional right for free exercise of religion. Would you agree with that statement?
Yes. Senator Kunesh.
Mr. Chair, Senator Kroon, yes, I would agree with that.
Okay,
Senator Kroon.
thank you, Mr. Chair. The next thing I had for a question was the inclusion of gender identity or expression in this proposed constitutional amendment. What exactly does the expression part of that mean?
Senator Kunesh.
Senator Kroon and Chair, we express ourselves in many different ways, visually, verbally, in so many different ways. Sometimes how a person dresses will cause people to treat others inequitably. And so whether we express ourselves either physically or visually or in those ways, that we do not want to allow any kind of inequitable recourse because of how a person would appear or speak of themselves or others. And so we want to make sure that those gender identities and those expressions that we see in our society today are not used against a person when it comes to equality under the law.
Senator Kroon.
Thank you, Mr. Chair. As I'm listening to that, I think it's kind of what you're saying, I think is kind of like speech related to gender identity, and speech in the way I'm using is not necessarily vocalized speech, but the broader definition of speech. But you could make the same inclusion on every single one of the categories that you have in this definition. You could have kind of race or expression thereof, the kind of, color or sexual orientation or the expression. I mean, you could include that. So I'm wondering why it's only included with respect to gender identity.
Senator Kunesh.
Mr. Chair and Senator, I don't have a reason. It's just that we would like to have that in there.
Senator Kroon, let me know when you're done here. Senator Westland
Yep.
also has some questions.
I'll just make, if you want to move, Mr. Chair, if you want to move on to other, I do have a statement, but I don't have any more questions. If you want to come back to me for that final statement, I'd be happy to pass it on to someone else, if that's okay with
It's
you.
up to you when you want to make your final statement, Senator Kroon, now or after Senator Westland is done.
I'll reserve. Thanks.
Senator Westland.
Thank you, Mr. Chair. On that point, and it's maybe a comment or a question, I'm not sure which it is, but if you go to the Human Rights Act for Minnesota, it actually, much of the language that is contained in this amendment is actually follows what's in the Minnesota Human Rights Act. And so is it the intention then of this constitutional amendment to then put into our Constitution what is currently in code in our statute?
Senator Kunesh.
Thank you, Mr. Chair. Yes, Senator Westland.
Thank you.
Senator Kroon, your final statement.
Thank you, Mr. Chair. Oh, did you, you had?
Senator Limmer is breathing a sigh of relief, Senator Kroon.
Thank you, Mr. Chair.
Senator Kroon.
I appreciate that. I hope that my comments and questions today on with respect to both of these bills doesn't give the impression that I don't believe in equal rights for women. I think, I have a mother, a sister, I have two daughters, and I certainly want them to have all of the opportunities that my father had, that I have, that my son has. I do have, I won't go back into my concerns over the previous Senate file. I've already covered that. With respect to this, I do have sincere concerns over the inclusion of gender identity or expression and enshrining that into our Constitution. I think that does create a a set of issues that our state will be dealing with that I don't think, I just think that will create a set of problems and a set of issues that most people in this state would not agree with at this time. And I think it could conflict with our religious liberties and freedoms that is also enshrined in our Constitution. So I have really a lot of concerns. Short of that, if that were not included in this, I would very likely vote yes on this, because I do believe that we should have equal rights for women, and we shouldn't discriminate against people based on that. It's already enshrined in law. I can understand the value, of adding it to the Constitution, discrimination based on race, color, sex, sexual orientation. I understand that, but my main concern is with the inclusion of gender identity or expression in this proposed constitutional amendment. So those are my comments. Thank you.
Senator Westland, any final comments? And we're going to turn to the chief authors for final comments and a vote.
And I understand that to be telescoping to me to be brief, and I will do my best.
That's correct, Senator Westland.
Mr. Chair.
Unless you want to stay here until midnight with the rest of us.
Hey, I don't. Thank you again for bringing this forward. And just to, I guess, respond to some of the discussion today, the purpose of this bill, when passed, is to put forward to the people of Minnesota what our values are. We have those values in our Minnesota Human Rights Act. We have already stated in code, in our law, that we as a state believe that people should not be discriminated against because of race, religion, disability, national origin, sex, marital status, familial status, age, sexual orientation, and gender identity. We have sort of the opposite problem that we had with the PRO Act. The PRO Act was based in a decision by our Supreme Court. What we have here is a code that could be withdrawn at any point from any future legislature and governor who would be willing to sign that. We should be implementing in our Constitution language that will absolutely prohibit discrimination, including discrimination against people because of gender identity. And in a week where we have just had yet one more transgender person beaten nearly to death, it is time that we state as a value in Minnesota, this is not acceptable, that we value every person for their special gifts, for their life, for what they bring to our community and our society. And I am very confident that if we put this forward to the people of Minnesota and let them make the decision, I am confident that they will vote to affirm this as part of our Constitution. Thank you.
Senate file number 37, Senator Kunesh, final remarks.
Thank you, Mr. Chair. And I believe Senator Westland must have been reading my mind because she took all my lines and made my final statement for me. I think it's really important that we take this to the people of Minnesota and let them decide. And so I would ask for your support.
Mr. Chairman.
Senator Pappas, on Senate file 37.
Mr. Chairman, actually, no.
On Senate file 37, Senator Ume Verbatim, do you have a motion?
Thank you, Mr. Chair. We're on Senate File 37.
Yes.
I move that Senate File 37 be recommended to pass and be referred. Oh, I'm sorry. I move that Senate File 37 as amended be.
It wasn't amended.
Nope.
No, that was for.
Okay. Give me a second.
That's why I was going to.
All right. Thank you, Mr. Chair. Senate File 37, I move Senate File 37 as amended.
No.
37 was not amended.
Okay. That's all right. We're on 37, it is not amended, and it's going to rules. Thank you. Okay. I move that Senate File 37 be recommended to pass and referred to the Rules Committee.
Senator Uma Verbaeten moves that Senate File 37 be recommended to pass and be referred to the Senate Committee on Rules. All those in favor say aye.
Aye.
Opposed? Motion prevails. To Senate File 47, Senator Pappas, closing remarks.
Thank you, Mr. Chairman. My closing remarks are that I move that Senate File 47 as amended be recommended to pass and sent to the Rules Committee.
Senator Pappas moves that Senate File 47 as amended be recommended to pass and be re-referred to the Senate Committee on Rules. All those in favor say aye.
Aye.
Opposed? Motion prevails. Thank you, members. Members, I'm looking at the agenda. I just want to note, I want to make sure we have full opportunity to evaluate the bills before us. We still have 4, 5, 6, 7, 8, 9, 10, 11 bills on our agenda, and it's 2:15. So let's just keep that into consideration as we are working our way through them this afternoon. Senator Gustafson, we're going to take up Senate File 2019. And it, okay, well, that's fine. We'll take them separately. And Senator Gustafson, will ask your testifiers also to come forward. Artika Roller and Mary Faulkner, please come on forward, take the chairs next to Senator Gustafson. Senator, go ahead and tell us what your bill does, please.
Thank you, Mr. Chair. Thank you, committee members. Thank you for the opportunity to introduce Senate File 2019. It's a bill that continues our ongoing work to ensure that victims and survivors of sexual violence receive a timely, trauma-informed response to our criminal justice system. Senate File 2019 creates a 90-day time frame for testing sexual assault kits. The provision ensures that law enforcement can effectively investigate a reported sexual assault, and victims and survivors can have the closure the completion of forensic testing offers them. We have made good strides toward ensuring that sexual assault evidentiary kits move in a timely manner from hospitals to law enforcement and from law enforcement to the lab. Establishing a testing window for our state crime labs is the final step that will ensure the evidence collected in medical forensic exams is tracked and processed as efficiently as possible. Our goal with this bill is transparency. Our current practice includes a timeline for each step of the process except testing. With the rise in violent crime over the past year, victims and survivors of sexual assault have had to wait up to 8 months for their kits to be tested, with no communication or information from the forensic lab. Law enforcement and prosecutors have had to wait on crucial evidence needed to conduct through investigations. These delays send the message to victims and to criminal justice professionals across Minnesota that sexual violence is not a priority. This exacerbates an issue that is already challenging to victims and advocates, that sexual assault is not taken as seriously as other forms of violent crime. These perceptions exist due to years of systemic disregard, leading to backlogs of untested kits, investigations not being conducted, and people who cause harm not being prosecuted. Changing these perceptions requires time and dedication from all sectors of criminal justice system, including forensic laboratories. Local jurisdictions rely on regional forensic labs, and how these labs choose to prioritize evidence testing has a ripple effect on how seriously sexual assault is taken in communities. I urge you today to vote in favor of Senate File 2019 to ensure that victims of sexual assault receive the response they deserve from our criminal justice system. The advocates of this bill also understand that in order to make this work, the BCA must be fully funded and their staff trained. We appreciate this, and the advocates of this bill, including myself, will be fully supporting the BCA's budget request. Mr. Chair, I have 2 testifiers today. I will let you choose who goes first, but we are ready to hear from them when you're ready, Mr. Chair.
Thank you, Senator Gustafson. I have Artika Roller first on my list.
Yes.
Go ahead, please state your name and identify your association, and go ahead with your testimony.
Chair, members of the committee. My name is Artika Roller. I'm the Executive Director of the Minnesota Coalition Against Sexual Assault, also known as MNCASA. MNCASA is a statewide coalition driving transformative culture change to address sexual violence through advocacy, prevention, and racial justice and system change. We have programs, 66 programs across the state of Minnesota, representing all 87 counties in Minnesota. The prompt testing of sexual assault kits is a survivor justice issue. When someone experiences a trauma such as sexual violence, they should not have to worry about whether or not their sexual assault evidentiary kit will be tested promptly, and the additional stress on how the delay could affect their legal case. Over the past year, victims and survivors of sexual assault have waited up to 8 months for kits to be tested without communication or transparency from forensic labs. The deprioritization of sexual assault kit testing is unacceptable and causes harm to victims and survivors. Testing delays communicate to victims and survivors that their cases are not a priority. They indicate that sexual assault is less serious and deserving of system responses than other forms of violence crimes. These messages can impact how communities respond to sexual violence and whether victims and survivors receive support. Testing delays also slow down investigations and cause law enforcement and prosecutors to wait on critical evidence. This means that victims and survivors spend more time navigating a criminal legal system that is often continue to traumatize them. Historically, sexual assault has not been taken seriously as other violent crimes. Victims and survivors of assault are often not believed, they're blamed, they're dismissed when they speak out about this crime. In Minnesota, we have seen backlogs of untested kits, victims and survivors not knowing what happened to their kits. In cases, investigations cannot be conducted, and people who cause harm are not held accountable for these crimes. Testing delays a larger society, or conveys a larger societal message that we do not take sexual violence seriously. Today, we have the opportunity to say something different in Minnesota. A 90-day time frame for testing sexual assault evidentiary kits is not only a justice issue for victims and survivors, it's a reasonable standard. It is fair to expect transparency in every step of the collection, submission, and testing of sexual assault evidentiary kits. There is not a current time frame for laboratory testing of sexual assault kits. Yet, hospitals must submit to law enforcement the kits within 10 days. Law enforcement is required to submit the kits to laboratories within 60 days. Laboratories should also have an expected time frame for testing. Many states have already passed legislation mandating a time frame for testing of sexual assault kits. It is time for Minnesota to join them as well. Victims and survivors of sexual assault in Minnesota deserve the closure of timely forensic testing of their sexual assault kits. By mandating a 90-day time frame, we declare that victims and survivors matter and people who cause harm will be held accountable. I urge you to vote yes today for Senate File 2019 to ensure victims of sexual assault receive an efficient, transparent system response. Thank you.
Thank you, Ms. Roller. Ms. Faulkner.
Good afternoon. Thank you, Mr. Chair and committee members. My name is Mary Faulkner, and I am the Criminal Justices Coordinator at PAVSA, the Program for Aid to Victims of Sexual Assault. Located in Duluth, PAVSA's mission is the elimination of sexual violence in southern St. Louis County through supporting victims, educating the community, and advocating for change. Since 2016, I have coordinated the City of Duluth Sexual Assault Kit Initiative. This project addressed previously untested sexual assault kits inventoried at Duluth Police Department and continues to implement promising practices for advocacy, forensic medicine, investigation, and prosecution. In this capacity, I help victim survivors navigate the criminal justice system. Over the past year, victims who have reported to the Duluth Police Department have had to wait up to 8 months for their sexual assault kits to be tested by the State Crime Laboratory. Victim survivors have shared with me how difficult this wait is. They have told me that their lives are on hold, waiting for their cases to move forward. Some victim survivors have expressed that they feel forgotten by law enforcement while they wait for their kit to be tested. In my experience, many victim survivors report to law enforcement and undergo a forensic exam because they are concerned that their assailant has already harmed someone else and/or is likely to commit another assault. Reporting sexual assault to the police is an act of courage. Victim survivors share their trauma and consent to an invasive exam that can last up to 7 hours. They take these difficult steps out of concern for their community and for all of us. In return, victim survivors deserve to know the timeline for kit testing, and this timeline should reflect the serious nature of the crime. Since 2018, Minnesota has passed a number of important victim-centered reforms to the criminal sexual conduct statutes, including timelines for how hospitals and law enforcement handle kits. A 90-day timeline for sexual assault kit testing is a crucial next step and the right thing to do for victim survivors. Respectfully, I ask you to support Senate File 2019. Thank you for your time.
Thank you. Any members of the public wish to testify? Not seeing anyone. Open the committee discussion here. Anyone on the committee wish to speak in connection with Senate File 2019? Senator Cruin.
Thank you, Mr. Chair. So as I understand the bill, it removes the requirements for the BCA to test these sexual assault kits, and it allows it to go to another forensic lab. Do I have that right?
Senator Gustafson.
Yes, thank you, Mr. Chair. The BCA is responsible for overseeing the kit tracking database, but hospitals and labs have access to update the kits that they're working with. Does that answer your question? Okay.
Mr. Chair.
Senator Cruin.
Thank you, Mr. Chair. My only question is what assurances do we have that that it will, the standards will be the same or at that certain standard that the BCA uses if these other forensic labs are conducting the examinations?
Senator Gustafson.
Mr. Chair, thank you. These are forensic labs that the BCA tends to work with in general. And so, again, they're still overseeing the kit track database. These are not, processes or things outside the realm of the quality level that they're used to. This just helps with the caseload. I might let my testifiers add to that. They probably have something a little bit more that's somebody from the audience is coming, detailed. But if that's okay with you, Mr. Chair?
Of course. Either of you testifiers have more information on this?
Chair,
Yes,
I
Ms.
don't
Roller.
have more information regarding that. My understanding is that our labs are certified, and whatever that certification may be. I think that they all have some type of state oversight, but I don't know exactly what that state oversight is. Thank you.
Senator Cruin.
Thank you. And I'll maybe take that offline with the BCA and the chief author just to make sure. There probably is some sort of certification that already exists that I'm not aware of, and that's entirely possible. But I think it's a good bill, and I'll just follow up offline just to make sure on that point. Thank you.
Mr. Chair, I do
Senator
have.
Gustafson.
Thank you. The main players are Hennepin County Sheriff's Office and Midwest Regional Forensic Laboratory, and they serve Anoka, Wright, and Sherburne counties. It's really a way to make sure that they fall into that 90-day. But again, they're all forensics that are labs that are accredited and familiar with the BCA.
Any further discussion or questions from members of the committee? Senator Limerick, co-author on the bill, do you wish to make the motion?
I do, Mr. Chair. I move that Senate File 2019 be recommended to pass. Where's it going?
Just being laid over. Just a moment, Senator Limerick.
Does it go? No money?
Senator Limerick goes to the floor. Senator
So
Limerick moves
moved,
that
Mr.
Senate
Chair.
File 2019 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed, motion prevails. Thank you, Senator Gustafson.
Mr.
you're
Chair, I
also
just
here-
was going to, if it's okay, I was going to thank Senator Limmer for being a part of this bill as well. I appreciate it.
Yes. And Senator Seeberger on this committee and Senator Pappas are also co-authors of the bill. So, next file, Senate File 1475 is before us. Senator Gustafson, what does this bill do?
Mr.
Ms.
Chair.
Roller, you can stay. I think you're listed for testimony. You're listed to give testimony on this bill as well, and Guadalupe Lopez can come forward as well for the same purpose. I am going to ask our testifiers to be concise in your presentations, please. It's been a long day, and it's going to be much longer for those of us who are still here. Thank you. Senator Gustafson.
Thank you, Mr. Chair. It's an honor to be presenting SF 1475. It's a bill brought forth in collaboration with the 6 statewide anti-violence coalitions. The bill would increase funding for crime victim services, ensuring that victim survivors have access to resources like shelter and housing, food assistance, child care and transportation, counseling, and legal advocacy to assist them in navigating an abusive or violent situation. The author's amendment adds the requirement that OJP develop eligibility requirements in consultation with coalitions with expertise in assisting crime victims. These coalitions include Violence Free Minnesota, the Minnesota Coalition Against Sexual Assault, Minnesota Alliance on Crime, Minnesota Children's Alliance, the Minnesota Indian Women's Sexual Assault Coalition, and Mending the Sacred Hoop Coalition. Though the Office of Justice Programs within the Department of Public Safety crime victim service funding is administered by way of a competitive grant process. In fiscal year 2021, the OJP funded crime victim service programs, provided support and services to 14,907 abused children, over 55,000 domestic violence victims, over 56,000 victims of general crimes, and over 8,000 sexual assault victims. Prior to the pandemic, these programs and services had identified on an additional financial need of $20 million a year to address the needs of victim survivors and their children. The gaps in funding experienced by crime victim service programs. So the pandemic has only exacerbated the situation as need has grown and funding gaps have expanded. We're therefore requesting an additional $25 million per year in base funding. There are 2 testifiers today, Mr. Chair. I will let you introduce them as you see fit.
Thank you. Again, I have Ms. Roller first on my list. Please go ahead.
Thank you, Chair, members of the committee. I'm Artika Roller again, and I am here with my sibling coalitions as we're testifying to support Senate File 1475, which provides a base level increase to crime victim services at the Department of Public Safety. These funds are needed so survivors can access the services and the support they need to take care of themselves and their family. We are seeking an annual $25 million increase to our base level funding for crime victim services. Additional funding for advocacy programs is needed. This funding is very urgent for our programs that we support. Crime victim services funding has not received an increase from our state in over 8 years. Emergency COVID funds and $5 million in survivor support grants provided in 2021 legislation was a one-time temporary emergency relief that is about to end. These funds will end at the end of this fiscal year in June. In addition, one-time funding being depleted, we have learned that our federal funds have also been reduced by $11 million this year. The VOCA funding from our federal government accounts for over 60% of funding for crime victim services in our state of Minnesota. A cut this large without a significant increase by state will mean that the advocacy programs will have to close their doors, and we're experiencing that now. Survivors in our state will be left out of programming and additional support. Our advocacy programs are reporting record numbers of people reaching out for services. Many of those who seek services are reporting more severe violence, complex family needs, and increased in mental health issues. We need a robust and long-term investment in crime victim services in our state, and we need it urgently. As with every helping sector, our sector is facing dramatic staffing shortfalls, so many advocates and victims and survivors in themselves are struggling to gain financial stability and advocates that are survivors that are working in this field, using their expertise to support people who are in similar situations. This work is incredibly difficult, emotional, and critical to our public safety. Programs want and should be able to pay their advocates the wages that they deserve. The demand for victim services has only continued to grow, and programs are struggling to remain adequately staffed to meet the current needs of these complex cases they're working through. Our rural Minnesota program shared, if our funding is decreased, I will have to let at least one, maybe two staff go. There will not be enough staff here to meet the needs of victims and survivors in our community. Programs serving victims of all types of violence report that they are losing advocates to employers like Walmart and McDonald's. They are offering higher wages than our advocacy programs can support. In the case of Hope Coalition in Red Wing, the agency was forced to close their emergency shelter in October due to the lack of staff. They are still unable to open their shelter due to the inability to pay advocates a living, thriving wage. This is a very small glimpse of what we are experiencing in the state of Minnesota and what's to come in communities across our state if we do not provide an increase in our base level funding for crime victim services. And I will turn it over to Director Lopez.
Ms. Lopez, welcome to the committee.
Thank you. Chair Latz and members, I'm Guadalupe Lopez, Executive Director to Violence Free Minnesota. We are here hearing from programs across the state that the requests for direct client assistance have increased significantly. We have heard that programs have spent funding originally intended to hire new staff, but have to go instead to be shifted to direct client assistance to meet the increased demand. Crimes and violent crimes in particular have significant financial impacts on victims and survivors. Direct client assistance funding would help crime victims with financial losses and increased costs that are a result of violence. Things like replacing broken doors, assisting with relocation costs, paying for uncovered mental health and healthcare costs, assistance with rental deposits, childcare, and more. A base level increase in funding for crime victims will support programs' ability to assist victim survivors with their housing needs. Domestic violence is one of the 5 key reasons why Minnesotans experience homelessness, creating a crisis for women and children. This is particularly crucial for Black, Indigenous, and other communities of color. In 2021, 24% of Minnesota victims of intimate partner homicide experience housing instability. As we increase access for financial stability and affordable housing, we increase safety for victim survivors of relationship abuse, and we work to prevent domestic violence. An increase in state funding for victim services would allow for increased work in violence prevention. Prevention includes safe and affordable housing, pathways towards financial stability. We can fund community education and healthy relationship trainings for youth to prevent violence from happening in the first place. Prevention also includes programming to transform abusive behaviors and to end the cycle of violence. In order to transform the landscape of violence in Minnesota, we must address repeat violence by providing funding for sexual violence prevention, domestic abuse transformation programming, restorative justice, offender accountability programs, and other programs to change abusive behavior. Many of our programs have had to stop providing this programming or are unable to start in the first place because of lack of funding. Victim advocacy programs have a direct and immediate impact on the public safety of Minnesotans. We are urging you to support Senate File 1475 for an ongoing increased base funding to crime victim services that will sustain and expand these critical public safety operations. We need your continued commitment to prioritize the safety of survivors and the relatives of all Minnesota families and communities across Minnesota. Miigwech, and thank you very much.
Thank you, Ms. Lopez. Members, we are going to be laying this bill over because it's a funding matter for possible inclusion in our budget bill. This time, are there any questions from members of the committee for the testifiers or the chief author? Senator Westland.
Thank you, Senator Latz. I just have a really quick question. Would an organization such as Mothers Against Community Gun Violence, who does provide services for survivors and victims of gun violence, would their organization be able to apply for a grant under this bill?
Mr.
Senator
Chair.
Gustafson.
Thank you, Senator Westland. This is really allocated for victims of domestic abuse and sexual assault, so that would be a separate, yeah. And
No.
maybe I'm wrong. Okay, maybe I'm wrong, yeah.
Chair, actually, there's 6 coalitions. So there's General Crime Victim Services, Sexual Violence, Intimate Partner Violence, Domestic Violence, and then also Children's. And so my understanding is this goes through OJP. So if they meet the requirements of funding through OJP, then they would be eligible to apply.
And members, I'll note that our cover note, the committee members received the memorandum from Chris Turner, our fiscal analyst, indicates the services could include victims of sexual assault, general crime, domestic violence, and child abuse. Any other questions or comments from members of the committee? Not seeing any, Senate File 1475 will be laid over for possible inclusion in our committee's budget bill. Thank you, members, and Senator Gustafson.
Thank you.
Senator Seeberger, bring your refreshments up with you. You have a lot of bills ahead of you. Senate File 1249.
Nobody saw that. Thanks for that reassurance.
Which one are 1249?
Senator Seeberger, to your bill.
Thank you, Mr. Chair, members of the committee. It is my pleasure to present to you Senate File 1249, which is a bill requiring the state to pay for medical examination costs for criminal sexual assault kits. Before we get started, I have an author's amendment that I would like to add to the bill to get it in the shape that I want it to be in. It is the A2 amendment.
Members, in your packet, you have the author's amendment. This is the first stop for this bill. Senator Seeberger moves adoption of the A2 amendment. All those in favor, say aye. Aye. Opposed? The amendment is adopted. Senator Seeberger, to your bill.
Thank you. The amendment that we just referenced makes a technical change to update the statute based on updates to the bill, and it offers clarifying changes brought forward by the groups working on this bill. Those groups include the Minnesota Sheriff's Association, the Office of Justice Programs, Minnesota Hospital Association, Sexual Assault Nurse Examiners, SANE Program Coordinators, the Minnesota Department of Health, and the Minnesota Coalition Against Sexual Assault. Senate File 1249 now does 2 things. First, it proposes the creation of a state-administered fund to pay healthcare systems for the medical forensic examinations they provide to sexual assault victims. Currently, payment for sexual assault exams in the state is the responsibility of the county where the sexual assault took place. The county payor system has resulted in several different challenges for healthcare systems, county administrators, and victim survivors. A state-administered fund will clarify the existing confusion on a variety of fronts. Payments will be uniform, so hospitals can effectively budget and have confidence regarding how to receive payment for the services they have provided.
The counties will no longer have to determine how much to budget for sexual assault exams, resulting in increased administrative efficiency. And finally, victim survivors can be assured with confidence what exactly will be paid for by the state fund. The state fund approach will help ensure that victim survivors are not billed in error or surprised by a bill refused by a county payor. Senate File 1249 will accomplish greater efficiency and equity for our counties, hospitals, and victim survivors across the state. Second, the bill clarifies the best practices for medical forensic exams. It ensures that victims of sexual assault in our state receive the best care and interventions. The bill also ensures that evidence collected at these exams is tested in a timely manner. Criminal investigations can move more quickly, and victims can experience the closure of knowing their kit has been tested to completion. All these important changes promote efficiency and equity for victim survivors, hospitals, and our 87 counties throughout the state. And Mr. Chair, I have two testifiers here today. M. Westerland from the Statewide Medical Forensic Policy Program, who is the Statewide Medical Forensic Policy Program Coordinator at MNCASA, and Brianna Heisterkamp, the Clinical Care Supervisor at Hennepin Healthcare. There should also be a letter from the Sheriff's Association in your packets as well.
I have on my list M. Westerland as our first testifier.
All right, thank you, Chair, and thank you, members. My name is M. Westerland, and I am the Statewide Medical Forensic Policy Program Coordinator at MNCASA, who you've already heard from my boss, Artika Roller, this afternoon. MNCASA is a statewide membership coalition and collective voice of organizations and individuals committed to ending sexual violence. It is my job to know what is happening throughout the state regarding medical forensic exams for sexual assault survivors. The fact is, the issues in our current exam payment approach have been known for over a decade, and systems professionals have been trying to develop solutions for just as long. Senate File 1249 is the culmination of our collective effort to improve this system for sexual assault nurse examiners, hospitals, law enforcement, county payors, and most critically, victim survivors. Currently, Minnesota is one of only 6 states in the nation that uses a county payor model. With 87 different county payors, all located in different county departments, many issues arise. Shifts in staffing, budgetary constraints, and confusion about obligations for payors are all challenges that can result in inconsistent or disparate payments for hospitals and clinics. Unfortunately, our county-by-county approach to exam payment is not working, and I often refer to it as a patchwork of payments because it really does vary that much. And I know that the letter from the Minnesota Sheriff's Association references some of the range in payment amounts and timelines. The clarification of best practices for medical forensic exams shifts Minnesota from a testing model for sexually transmitted infections to a proactive treatment model. This is in line with guidelines issued by the Centers for Disease Control and reflects best practices in forensic medicine. Perhaps most critically, Senate File 1249 will help to ensure victim survivors of sexual assault receive high-quality, trauma-informed services. The creation of a state fund will help ensure equity in billing and payment across jurisdictions and reduce the likelihood that a victim survivor may inadvertently be billed for their medical forensic exam. And I just wanted to note that that isn't something that should happen in practice, but as a result of the complexity of our county payor system, it is something that does happen. And it can be very upsetting to receive a bill after you've been assured that you will not. Minnesota has made great strides over the past several years to ensure that our state policies for sexual assault victims reflect national best practices. Senate File 1249 is another important step toward ensuring victim survivors of sexual assault in our state receive the best possible services at every step of their journey toward healing and justice. Thank you.
Thank you, Ms. Westerland. Ms. Heisterkamp, go ahead.
Thank you, Mr. Chair and members of the committee. I'm Brianna Heisterkamp, forensic nurse examiner or sexual assault nurse examiner and supervisor of the Hennepin Assault Response Team at Hennepin Healthcare in downtown Minneapolis. We are a forensic nursing program, primarily providing care to survivors of all ages who've been sexually assaulted or abused. We serve 12 hospital locations across many counties and across many hospital systems in Minnesota. I have sat with hundreds of patients in these exams and assured them that they would not be billed for my services. I should be able to confidently make this assurance, but I can't.
because I have also spoken to patients who have been mistakenly billed for the care they were provided in a medical forensic exam. This inconsistency is a stress survivors should never have to face, but it becomes less of a rarity when healthcare facilities grapple with uneven reimbursement from the county payers. As you've heard, Minnesota is one of only 6 states that is using a county payer model for reimbursement of sexual assault exams or medical forensic exams. My program operates in multiple counties, and we currently receive different levels of reimbursement from each county. This uncertainty presents challenges to program stability and sustainability. Healthcare providers doing this work, whether they operate out of a rural hospital, a level 1 trauma center, or a community clinic, should be able to keep their focus on providing exceptional care to every survivor. Senate File 1249 will help make this possible. The creation of a state fund will bring consistency to billing and to payment. The clarification of best practices for medical forensic exams also included in 1249 would transition Minnesota to a proactive treatment model from the current testing model included in the current bill. My program and others across the state typically manage sexually transmitted infections by offering preventative treatment, which is in line with recommendations from the Centers for Disease Control and Prevention. It also reduces the additional stress of multiple follow-up appointments for the survivor. Healthcare providers who do this work need the consistency that this Senate file will bring. And it's an important step in ensuring our focus remains at the bedside, providing trauma-informed, patient-centered care to survivors. I urge you to support this bill, and in doing so, support the sustainability of this important service in Minnesota, and most importantly, the care of victim survivors. Thank you.
Is there anyone else in the public that wishes to testify in connection with Senate File 1249? Any members of the committee have any questions or discussion relating to the Senate file? Senator Seeberger, there are some substantive changes to chapters of law that relating to health, including changes to the standards of care and mandated submission of reports for costs of medical examination, although that's under Chapter 609. But I think with the substantive changes beyond hospitals to other healthcare facilities, I think the Health Committee needs to have an opportunity to weigh in on that. I don't expect it'll be a problem, but, and so I think the bill's going to need to go to that committee. And then the only other thing we're trying to figure out here is what we do with regard to the appropriation. I'm reluctant. Well, maybe what we do is, why don't we send it to the HHS, and then between now and then we can decide if it's to be brought back here for possible inclusion in our budget bill, or if it's going to go to the floor with a recognition that if there's that the budgetary impact would be probably kept in this committee, and the bill simply would not become effective unless it's funded. So I'm not seeing any other questions from the committee, so I think the appropriate motion would be that Senate File 1249 as amended be recommended to pass and be re-referred to the Senate Committee on Health and Human Services.
Mr. Chair, so moved.
Actually, Senator Seeberger has the opportunity to move her own bill. Senator Umer verbatim. So Senator Seeberger, would you like to make that motion?
Yeah, I will make that motion, Mr. Chair.
Senator Seeberger has so moved. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you. Senate File 1249 is on its way. Senate File 10, Senator Seeberger, petroleum refineries workforce issues. And if the two testifiers that I have listed, Brendan Cummins and Bruce Newstad, can come on forward, please. Senator Seeberger, to your bill.
Thank you, Mr. Chair, members of the committee. I am so pleased to be before you on Senate File number 10, which is the Skilled and Safe Workforce at Refineries bill. This has been heard in labor and was passed out of labor with enthusiastic support, and we now come before you in judiciary. Before we get too far into it, I do have an amendment. It's the A13 amendment, which reflects weeks of negotiation since the Labor Committee up until today among all the stakeholders, and I'm pleased to say that they have reached this agreement. And the A13 amendment deals with the provisions of this bill which are subject to the jurisdiction of judiciary. So at this time, I would move the A13 amendment.
So Senator Seeberger, since this is not the first stop, it's not an author's amendment, so why don't you describe to us basically what the bill does and tell us what the current provisions are on the bill relating to the portions within our jurisdiction, and then how you propose to change it with the A13 amendment.
Thank you, Mr. Chair. Senate File number 10 sets forth that for workers in petroleum refineries, which are extremely hazardous places to work, that workers meet a minimum threshold of training. And that minimum threshold of training is what one would get by going through an apprenticeship program. So the concern was raised by some workers in a refinery that they were working alongside of folks that they had no knowledge of what their skills were, what their training was, whether the guy next to them knew what they were doing or not. And those are the people who raised the alarm about this situation, which led to this bill. That's kind of the thumbnail sketch of what this bill does. My testifiers can go into greater depth on that. The amendment, as I said, reflects weeks of negotiation and does a few things. Number one, it gets rid of the private right of action that is currently seen in the bill. And it clarifies or tightens up the penalties section. Again, the stakeholders all came to the table, and this is what they agreed to, and this is what I would like to honor.
Senator Seeberger, could you please walk us through the stakeholder agreement then on the penalties provision?
I will do, I will, unless you're, want me to do it?
Unless your testifier wishes to do that.
I can do it if you want.
You can do it.
Okay. All right. So what we're looking at is changes made to subdivision 3, which is the penalties. And they have agreed that number one, let me see, we've just changed this, so I'm looking through it myself.
I can do it if you want.
Oh, I'll turn it over to my testifier then. He's maybe ready to hit it. Good afternoon,
Go
Mr.
ahead
Chairman.
and identify yourself and tell us your affiliation, and go ahead.
I'm Brendan Cummins. I'm attorney for the Minnesota State Building and Construction Trades Council and the Minnesota Pipe Trades Association. I'm testifying in support of the proposed amendment to Senate File 10. So just to walk through this amendment, which you have before you, as the senator explained, this is the result of a compromise between stakeholders. The linchpin of it is to remove the private right of action, so there would no longer be a private right of action to enforce this legislation that provides for refinery safety. But in the absence of that, you need some type of meaningful remedy to ensure accountability and compliance. And so what the remedy that is available is civil fines issued by the Commissioner of Labor and Industry following a complaint and investigation. The fines would range between $5,000 and $10,000 per violation. The amount of the fine would depend upon the size of the violator's business and the gravity of the violation, as is typical with fines issued by the Commissioner of Labor and Industry. These types of civil fines are very common, issued by the Commissioner. Other types of violations, like related to payroll records, commissioner investigations, cooperations with commissioner investigations, notice posting obligations. They're all enforced by the commissioner using fines. So the civil fine method is something well within the commissioner's purview. An owner or operator would be found in violation if it failed to include in its contracts or subcontracts the requirement of using a skilled and trained workforce as defined by the statute. In other words, a workforce that meets the registered apprenticeship requirements set forth in the statute, or if they fail to enforce or ensure compliance with those requirements. Then a contractor or subcontractor would be found in violation if they fail to ensure or fail to use a skilled and trained workforce as defined by the legislation. So what we have here, the compromise is basically remove private right of action and provide for civil penalties or civil fines, which is a common way in which the Department of Labor and Industry ensures compliance.
Thank you, Mr. Cummins. Any questions from members of the committee relating to the A13 amendment? Not seeing any. Senator Seeberger moves adoption of the A13 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Seeberger, I also have on our pre-identified witness or testifier list, Bruce Newstead. Mr. Newstead present? Okay, and I did have a request from Rick Heller to also testify on this bill. Mr. Heller, come on forward. Going to ask you to be concise in your testimony as well. And welcome to the committee.
Can you pass the sign-in sheet? Thank you.
Thank you, Senate Chair or Ron and people on the Judicial Committee in the Senate today on March 3rd. My name is Rick Heller. I unofficially represent the twice exceptional print disabled. You can find that currently in the Governor's Bill 1311. He's changing out the word handicap next to blind with print disability. Currently, basically, are both lingual words. I myself have been a vested carpenter for 40 years. And my experience is there's always a great need for the refinery to have carpenters get out to the refinery. It appears there is shortages, and as we have the people getting older and finding enough people to provide that employment out there and work, it's relevant because, first of all, I don't know if anyone knows it, maybe you do, but the apprenticeship program in the Twin City here requires a GED or a grad. Perhaps that's essential. However, there are people that don't have their GED, and my guess there are in the workforce and they're very skilled. Something to look at as it relates to the Minnesota pipeline, making sure that flows effectively. Colleges are and technical schools are lowering the bar also on GPAs. One thing you might want to consider to plug in is the apprenticeship ratio standard.
Mr. Heller, I apologize for interrupting you, but the question before the Judiciary Committee today is only the penalties provisions in the bill. The other provisions of the bill are Labor Committee jurisdiction, and this bill will be going back to the Labor Committee from here for further evaluation. So if you could please focus your testimony on the provisions before this committee, I'd appreciate it.
I guess with penalties involved, just for the sake of relevance, you certainly call me on it. However, it's my understanding in order to be involved in the training, such as Pro 10 at the apprenticeship training center, they have to be signatory with a contractor that has a contract with the union. What's potentially problematic there
is since they're double-breasting out at the refinery, and maybe they don't have the Pro 10 or the academic within an apprenticeship program as it relates to the fines, it does take away that element, especially when you get into the 60 to 85% quartile. If you would just audit the movement in the refinery, you would find out they likely cannot man that. I think that's relevant to relates to fines per individual or group. I think it's something that they open their records about that. The other one, even though it's labor related, is those violations of those expensive fines. They have numerous days of training before you even can enter there. I went to those trainings. Obviously, OSHA will have to meet them out there, or Department of Labor Industry has to meet them with their special person, obviously, out there, because it's such a tight place in their work. As far as become certified or qualified in Pacific training, that might relate to some of this. Perhaps that's Department of Labor again. However, the piece of that is qualification versus certification. Carpenters are not required to be certified in the state of Minnesota, if that's relevant or not as far as the fines go. However, again, if they're meeting, if the union can meet those things out there, great. But I think when it comes to those fines, they have a goal to meet 70% of the work market. But this big thing is about people's choice to be union or not. That's one of the few places they do have contracts, I'm sure, with the refinery, but they have to double-breast them out there. But that really actually gives them an opportunity to talk to the non-union people out of state as well and perhaps convert them over, but not to force them to get training. For instance, if a apprentice has to get training to be out there, and that ratio is relevant to the fine. The piece of this is ratio can also impact the fine because it's related to each individual or a group. So that's I think basically what I have to express. I'm certainly open to any further questions on this, but again, thank you for testifying on this matter.
Thank you, Mr. Heller. I know you waited all day to be able to be here to testify on this bill. I appreciate your patience.
Just for the record, at the beginning of the meeting, I asked that the screen would be turned on and captioning, and even just a minute ago, I sent another note in. It's out in the hallway, but I sit in these meetings, and it's kind of isolated me out in the hallway substantially, and I would ask that you consider just to turn it on automatically if it's possible, and put the captioning big enough and put it on the top of the screen. I most effectively acquire information by seeing and hearing it, and I think a lot of other people would appreciate that too, since I unofficially represent twice the exceptional in the print disabled. Thank you.
Yeah, thank you, Mr. Heller, for that suggestion. We'll see what we can do to make that possible. Does Mr. Cummins or Senator Seeberger wish to clarify anything in response to what Mr. Heller had to say about making sure the appropriate workforce persons are covered by the penalty provisions?
Mr. Chairman, I have no
Cummins.
response.
Okay. Senator Seeberger?
I don't have anything to add in that regard.
Okay. Mr. Heller, I'll just note, it appears that in the bill on lines 2.18 through 2.26, it does have a very detailed definition of skilled and trained workforce, which includes the apprenticeship references for registered apprenticeship program. So hopefully that language is inclusive enough to apply to the persons you're concerned about and make sure that they are protected under the penalty provisions in the bill.
Just, Chair, just protections, experience can speak a lot too, unnecessary training. Just because you go to training and it's a non-pass, non-fail thing, even when you go to these facilities, if you know about that, there are certified places they have to have a pass, but the qualification doesn't require that. So just for the record, just because you can attend a class and they go over the answers with you on the test, doesn't mean you can do it. It's really about experience in the workforce. Thank you again.
Thank you, Mr. Heller. Appreciate your sticking around today and testifying before the committee. Anyone else want to testify on this? Don't see anyone in the audience raising their hands. Any committee questions or comments? I'm not seeing any. Senator Seeberger, I'm told this is going back to the Labor Committee for consideration of, I suppose, amending in additional stakeholder agreement provisions or something to that effect. Is that right?
That's correct, Mr. Chair.
All right. Senator Seeberger then moves that Senate File Number 10 as amended be recommended to pass and be re-referred to the Senate Committee on Labor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you. Senator Seeberger, Senate File 1019 on soft body armor reimbursement grants. And members, I am told the plan here is to lay this bill over for possible inclusion. Let's hear from our Senator Seeberger. Tell us what this bill does.
Thank you, Mr. Chair, members of the committee. Senate File 1019 would work to expand those eligible to receive funding to purchase soft body armor. The legislature in 1989 established a soft body armor reimbursement fund for law enforcement. This armor is defined as Department of Public Safety vest reimbursement program, and it defines the soft body armor eligible for reimbursement as one front and one back ballistic panel, one soft trauma plate, 2 concealable or authorized carriers, and 1 hard trauma plate. The state will reimburse up to 1/2 of the purchase cost of the above items, and the bill expands eligibility for reimbursement under this program to firefighters and emergency medical service providers. This is a part of the governor's budget recommendations. I will say on a personal level, full disclosure, as you all maybe know, I'm a paramedic, and I work for a service that does provide us the option to purchase body armor to wear on the job. The company will pay for half of it, the employee has to pay for half of it, and the cost of the entire body armor system is about $900 to $1,000. So it's $450 to $500 out of the employee's pocket. This particular bill would relieve that burden and allow those of us out on the streets to wear the type of protective body armor that we feel is appropriate. With me to offer a few thoughts is Buck McAlpin from the Minnesota Ambulance Association.
Mr. Chair and members, thanks. Buck McAlpin, the Minnesota Ambulance Association. I'm also here with the Minnesota Fire Chiefs, and I said I would represent them today. We've worked on this the last couple sessions with the fire chiefs. Senator Seeberger did a great job as a paramedic describing it, and we've just witnessed quite an increase in usage where our EMS workers and firefighters across the state have been utilizing body armor. Unfortunately, we're still hearing instances where fire trucks and ambulances are just routinely shot at throughout the metro, and we think this is a great way to offset some of the costs. They have to be replaced about every 5 years, I believe it is now, and we really want to thank the governor also for putting this in his budget proposal, and I believe he added another $1 million into the fund of the $745,000 that the Department of Public Safety had. So they did make a commitment also to have some more funding into this. But we thank you for your support.
So members, the fiscal note on this is the governor's budget. This is included in full in the governor's budget. Are anyone else wish to testify on this? Any members of the committee have any questions or comments? Not seeing any. All right, members, we will lay Senate File 1019 over for possible inclusion in the budget bill. And thank you, Mr. McAlpin.
All right, thank you.
Senator Seeberger, Senate File 1595.
Thank you, Mr. Chair, members of the committee. Senate File 1595 is a bill that amends third and fourth degree burglary crimes to include situations where a person enters a building that is open to the public with the intent to steal or does steal while they're inside. This currently isn't considered burglary, as the crime generally requires the building involved to be one that somebody isn't allowed to enter. This closes a loophole for circumstances where one enters a mall or a school or other building generally available to the public and then steals something. So this was one piece, I believe, of Senator Limmer's bill. It's gone. Dealing with organized retail theft that passed out of committee in 2022 but died after that. So we are looking to enact this bill to close that loophole.
Is there anyone in the public that wishes to testify in connection with this bill? I don't have any testifiers on our pre-assigned list here. All right, I do have a question, Senator Seeberger. Council informs me that this would not include a school building because lines 1.12 and 13 exclude subdivision 2 paragraph B buildings. Can you actually, same thing with line 2.15 for the fourth degree burglary. Do you know why this was proposed without including public schools, or is that an intentional omission? Where is that?
I do not know.
Yeah. So council informs me that in subdivision 2 of this, of the statute, 609.582, burglary in the second degree does cover school buildings and other government buildings and a few other buildings as well. So that seems to be the general intent. That provision is a little bit more specific as to the elements of that offense, but school buildings are covered. They're entering it without consent and with intent to commit a crime. So actually, there is a question of the without consent entry for a government building. A building like this one is a government building, and the general public is invited to enter as they wish, at least while we're conducting business within the building, I suppose. So the question of whether someone who came in here and committed a crime would be committing technically a burglary or not. Well, we can think about that question and not try to fix that on the fly here today. The intention, members, is to move this to the floor, I believe. Any questions or comments by members of the committee? Senator Cruin.
Thank you, Mr. Chair. I guess that was precisely my question. When I think about how this could relate to a school, just last night I went to my son's basketball game, youth basketball game in Coon Rapids Middle School. It was open to the public. Certainly welcome to go in there, but I suppose there could have been many opportunities for me to steal things while I was there if I were so inclined, and I would hope that would be a criminal activity, and I think your bill would cover that if the exception wasn't in here, and I guess that was my question, is whether that would be covered somewhere else, but somehow I think that would need to be covered, so I'll do a little research myself here.
Senator Seeberger, we're having a discussion with fiscal and council regarding the bed impacts. I'm going to ask Mr. Turner to explain the fiscal implications of this bill. Mr. Turner.
Yes, Mr. Chairman and members. There's a fiscal note for this bill. It's in process. It's not public yet. But the bill does have a bed impact. The Sentencing Guidelines Commission estimates 5 additional beds in 24 and 11 additional beds in 25 and subsequent years. And that comes to the cost to the Department of Corrections of $49,000 the first year and $155,000 the second, and then $203,000 the third, and continuing. This bill needs to be connected to its funding, which is going to determine where it goes, Mr. Chairman.
All right, so as some of you know, it had been my goal to pass policy changes independently of the budget and just make sure we carried the money in the budget. However, it appears that the guidance from our leadership about how to handle these is to do it the way that we have done it in the past, at least for now, which is to, even though there are policy changes, keep the policy linked to the fiscal implication of it and put those in the budget bill. At least for now, I think what we'll do is we'll lay over Senate File 1595 for possible inclusion in our budget bill. That will also, frankly, give an opportunity while the bill is still in the Judiciary Committee to consider how to handle the question of government buildings, including public schools, and whether we want to clarify that at all in light of the purposes of the bill that's before us. So, with that said, Senator Seeberger will lay Senate File 1595 over for possible inclusion. Next up, Senator Seeberger, Senate File 1258.
Thank you, Mr. Chair. Members of the committee. Senate File 1258 tackles the issue of damages received in a sexual harassment or abuse settlement. What we've found is that when folks are embroiled in a sexual abuse or harassment dispute, receive a settlement, the employer will characterize those funds as wages or severance. And this has a couple of undesired effects. Number one, the employee then is required to report it as income. Number two, the employee who is usually off work trying to find a new job loses their unemployment benefits. And number three, the employer gets the deduction for the payroll expense. So Senate File 1258 seeks to resolve those issues. It would prohibit settlements between employers and employees related to sexual harassment or abuse being provided as wages or severance, such that an employee would not be obligated to report these as income, nor would they lose their right to receive unemployment benefits.
Senator Seeberger, do you have any testifiers in connection with this bill?
I do.
All right. Why don't you have them come forward, please?
Thank you. Wasn't sure you weren't on my list, so I'm glad you're here.
Who would like to go first?
Thank you, Mr. Chair, members of the committee, Senator Seeberger. My name is Julie Risser. In 2014, I signed a non-disclosure agreement with my previous employer. Back then, I didn't know NDAs really aren't regulated.
I didn't have time to investigate. This was before sexual harassment cases made headlines. I didn't know then, but what I had experienced was the norm. I went through common stages of on-the-job harassment. I ignored my harasser, hoping it would stop. I told my harasser to knock it off. The employee handbook messaged zero tolerance for sexual harassment and victims must report. So I reported in annual reports. Year after year, nothing happened. I went to HR. The rep refused to document my experience. Later, I learned from a state of Minnesota unemployment trainer I shouldn't have gone to HR. HR protects the employer. Zero tolerance means HR denies sexual harassment exists. My contract was not renewed. It's common for people who report to lose their jobs, while those who harass remain employed, get promoted, and gain power over more people. And that's what happened in my case. I felt and I was isolated. My husband and I needed my job to support our family and our 2 daughters. I hired an attorney. I didn't want anybody to go through what I had. I thought this would make a difference. I thought it was the responsible thing to do. We reached an agreement. The term in it was settlement, not severance. There was nothing about income taxes. When payment came, I was stunned. It was a sliver of the validation I had agreed to, and even the state of Minnesota got a cut. My unemployment benefits stopped. I couldn't access them until the total of my settlement had been prorated out. I couldn't use settlement funds to retrain. My expertise was narrow. I would have had to move out of state for a job that matched my skills, and that was not an option. My parents and many extended family live here. My employer benefited. Wages are deductible. Avoiding settlement payments also keeps insurance rates down. It's paying settlements as severance enables employers to conceal harassment and not reveal risk. There's no need to acknowledge victims. It re-victimizes and it shores up systemic gender inequities. I vividly remember seeing the cut Minnesota got from my sexual harassment settlement. Senate File 1258 will stop others from having this experience. The other thing is that when you get your settlement and it's paid this way, it can bump you into another tax bracket. It will make it easier for people to retrain and get back into the workforce. And if I had been able to focus on that, it would have made a tremendous difference. And as we look at the situation today, there is a labor shortage. I would think there would be a lot of interest in making it easier for people to retrain. Thank you for your consideration.
Thank you, Ms. Risser.
Chair and committee,
Ms.
thank you. Again, my name is Artika Roller, representing the Minnesota Coalition Against Sexual Assault. And I wholeheartedly agree with Ms. Risser that allowing employers to make abuse settlement payments as a severance compounds the harm and allows employers to hide the record of wrongdoing. Severance pay indicates that an employer was severance pay indicates that an employee was simply let go, whereas a record of a settlement indicates the wrongdoing that occurred. A victim and survivor receives less money if they are paid severance because it's subjected to federal income tax and state income tax. And people who receive severance are also not available for unemployment benefits for a period of time, which can cause financial insecurity for victims and survivors. Severance pay again, is tax deductible by employers, meaning that the employer could claim a sexual harassment settlement as a business expenses on their taxes. Victims and survivors of workplace harassment or abuse face loss of wages, unexpected medical and mental health costs, barriers to assessing unemployment benefits. Many victims and survivors lose their jobs or are forced to quit because their safety and well-being is at risk. They may also miss out on career advancement opportunities, which means future loss of wages. Settlements can ease the burden of loss of wages and help with medical or therapy bills. A settlement may also represent a victim's and survivor's best chance to get some form of legal justice. Some settlements may also protect a victim and survivor's right to disclose information from sexual harassment. Everyone deserves to be treated with dignity and respect at work. Employers should not be able to hide their wrongdoing and prevent damages to their reputation by claiming a sexual harassment as a settlement, as severance instead of a settlement. Vote today to support victims and survivors by prohibiting payment of sexual harassment settlements as severance. Would you please vote yes for Senate File Number 1258? Thank you.
Thank you, Ms. Roller. Are there any questions or comments from members of the committee? Senator Cruin.
Thank you, Mr. Chair. My concern about this is, and I understand the story that you went through, and I'm sorry I don't remember your name.
It's Julie Risser.
Ms. Risser. But my concern with this, and I have not practiced in sexual harassment cases or employment law, so I'm getting a little bit out of my comfort zone here, but I have done a number of litigation, and I know that reaching a settlement agreement is very difficult, and it takes a lot of time and effort. Oftentimes mediation is involved, sometimes multiple mediations, and some of the more difficult settlements that I've been a part of, we've had to be very creative on both sides. And so my concern with limiting how an employer and employee enter into a settlement agreement will make settlements more difficult. That's my concern. And I totally understand where you're coming from. If we have an employer and an employee who is unrepresented by a lawyer, then I could get totally on board with this. But it seems to me if the employee has a lawyer, the lawyer should be able to explain the consequences of the settlement agreement, including the tax consequences, including the severance pay, including unemployment benefits, and all of the issues that we're talking about here. A competent lawyer should be able to explain those terms. And I understand that you did have a lawyer in your case, and without having all the facts, I don't want to say anything, but perhaps the level of representation that you had was inadequate if the lawyer was not explaining those things to you. That absolutely should be part of the lawyer's job, to explain the consequences, the real-world implications of a settlement agreement. And so I'd be more comfortable with this if it were limited to cases where the employee is not represented by a lawyer. And I don't know if it's even possible to have an amendment to that. But if maybe to Senator Seeberger, just your general thoughts on that.
Senator Seeberger.
Thank you, Mr. Chair. Senator Kroon. I think, I hear what you're saying, but I don't necessarily share the same view that this bill would make settlements more difficult to attain. It may well be that a truly effective attorney would have the ability to explain real-world effects of settlements, but why should an employer be able to take advantage of a victim of a sexual assault or harassment to their detriment? And that's really what we're getting at here. It's not that these aren't adequately explained, or Ms. Rizzer's attorney wasn't an effective attorney. It's really who should be bearing the costs here. And if a victim is forced to leave their job and relive the experience by bringing a claim, why should that victim survivor then have to incur the detriments of being taxed on these proceeds and losing their unemployment benefits? And that's really what we're talking about here.
Senator Kroon.
Thank you, Mr. Chair, and I appreciate that response. I just can envision perhaps there are scenarios where where you do have, and I don't have an example at the ready, but I can envision there could be scenarios where you do have two competent lawyers that are hashing out a settlement, and there might be reasons why they might want to structure it in a more traditional way that might run afoul of this bill. And my concern is that if you have two parties should be able to freely contract, assuming, and I don't want anybody taking advantage of anybody, but assuming that they're both competently represented by lawyers, I feel like they should have the ability to structure it this way if there's a particular reason why both parties think that that should be the way it's done in that particular case. And that's my only concern here. Thanks.
Members, council has a suggestion for how to addressing the effective date, since this does affect contracts. Ms. Risser?
I would just like to say, as somebody who has gone through this, to be taxed by the state of Minnesota on my harassment settlement, that's unacceptable. And what the status quo allows to happen is for attorneys to, change the language from settlement to severance. And that's what happened in my case. And it also, with this construct, causes so much harm to happen. Because again, it's the insurers who don't find out about it for institutions. It allows harassment to continue. And, you can talk about competency in the legal profession, but you also need to talk about ethics. And if you're settling in this way, it allows institutions to continue and to allow the harassment to just keep on going. There's no consequence. And this, is one small step in trying to change the situation so that you cannot hide the settlement as severance. If it was a physical injury, it would not be possible to do this in this way. But because it's sexual harassment, this is allowed.
Actually, I do have a question then for counsel on this, because sometimes these claims arise, and part of the claim is for lost wages. If there's been a termination and the allegation is the person should not have been terminated, then part of the damages calculation might include lost wages. And I'm familiar with settlements in which sometimes the settlement amounts are split. Some of it is attributed to lost wages or lost income, and some of it is attributed to the equivalent of personal injury or pain and suffering, which would be taxed differently. So what would the impact here be, the way this is written, if the damages actually are being asserted, measured, calculated in some way that does in fact include lost income, lost wages? I know in the claims that I've been involved in, we'll assert, if it's a pure sexual harassment and doesn't include a wrongful termination component, I think that's one thing. But how is that distinguishable the way this is written when you got multiple claims? Let's say there's sexual harassment and the person quits as a result, or the person is terminated. And so kind of mixed in with the whole milieu is a year and a half of lost salary or some reduction if they couldn't find a comparably paid position promptly. How would this language affect a settlement that had multiple components to it?
Mr. Chair,
Seeberger.
I've got two answers to that. Number one, if a plaintiff wanted to bring claims of wrongful termination and sexual harassment or sexual abuse, conceivably, one could negotiate damages attributable to each. But I think what we're talking about here in a broader perspective is a policy statement, in that if we're talking about sexual harassment and sexual abuse, which leads a claimant or plaintiff to leave their job, part of their measure of damages is going to be not only the emotional harm and the impact upon their life, but the economic loss that they suffered, which would be measured in lost wages or inability to earn income. So I think at a policy level, we're talking about, you know, how do we treat this? When we look at like a personal injury action, you know, lost wages, medical expenses, pain and suffering, those are the things that are added into the verdict or settlement. And we all know that personal injury damages, a verdict or settlement, is not taxable income, even though it includes wage loss and loss of earning capacity. Those are not taxable. So I think we're looking to treat this the same way. From a tax perspective, and this is a conversation for the taxes committee, but from a tax perspective, given that at a federal level, this isn't necessarily how these are treated, we can only deal with this at a state level. I think as a state, we need to make that policy determination, and that's what we're asking for here.
So I don't do personal injury work specifically, so if there's a settlement in a personal injury case and some component of that settlement involves lost income, are you saying that that is not treated as lost income for tax purposes, that it's not taxable at all?
That is my understanding. It's normally never pieced out. So a personal injury settlement will be a lump sum figure that plaintiff will be able to accept as a personal injury settlement. But if one was to go to trial, what the jury is asked to fill out on the verdict form is the amount of damages for past and future pain and suffering, past and future medical expenses, and past and future lost wages and loss of earning capacity. So the practical reality is when a plaintiff goes in and negotiates a settlement, they go to mediation, they walk out with their settlement check, the discussion that was had includes all the elements of damages that plaintiff can bring, but they receive it as one personal injury settlement. In the context of sexual harassment and abuse, if there is a personal injury component, that piece is not taxable, or a physical injury component.
Senator Kroon.
Thank you, Mr. Chair. I think you've convinced me that this shouldn't be taxed. That's very persuasive. I still have a problem with the first part, which is prohibiting the structure of a settlement agreement. And I don't know if those two things are directly tied to one another or not. I don't have a problem actually with a settlement in this being treated like a personal injury settlement in terms of taxation. Again, that's probably not for our committee here anyway. But I think you've convinced me on that. But I'm still uncomfortable prohibiting the settlement agreement itself from being structured that way, as long as both parties have a lawyer. I don't have a problem with it if the employee doesn't have a lawyer.
So I'm trying to figure out the incentives here. It sounds like it's is part of the purpose here to, not sure if this is the right term, so forgive me if I'm getting this wrong, but to undermine the value of a non-disclosure agreement in a settlement provision? Because I know there's sort of the big picture, we don't like non-disclosure agreements approach, and from the big picture, I agree. But in individual cases, there are a lot of times when that's the way to get a settlement, rather than go to trial, and people are willing to accept that even if it doesn't feel quite as good because they get at least financial compensation for their losses. So is part of the purpose, or at least I think part of the effect here, would be to reduce the advantage of a non-disclosure agreement as part of a negotiation. Am I understanding just analytically, am I understanding it correctly?
Mr. Chair, not necessarily. The way I understand it, and now we are straying into tax law, which is kind of outside of my area of expertise. The way I understand it is the use of a non-disclosure agreement versus the not having a non-disclosure agreement has two different treatments under federal tax law. So this is trying to capture that situation where the employee would be on the hook for claiming these as wages and then losing their uninsured, unemployment benefits. Thanks. I was going to say uninsured motorist. I was going in the wrong direction. So
we can never really escape our day jobs, can we?
So the idea here is, I mean, really when we boil it down to, it's adding insult to injury. So a plaintiff is coming out of this terrible situation. They're forced to sign a non-disclosure agreement. The least we can do is allow them to enjoy the proceeds of their settlement without having to report their income or lose their benefits. So the technical piece of referencing a non-disclosure agreement, as I understand it, ties it into the verbiage of the federal tax law.
The problem is your
Ms.
settlement ends up going to cover your daily expenses, and you can't use that to retrain, and you can't access your unemployment, and you've got a family to support, and you're only getting a sliver of what you thought you were going to get.
All right, any other further questions or discussion on this? Mr. Turner has advised me that there are tax implications, as I recall, that or the fiscal note that accompanies this is from the Department of Revenue, so this bill needs to go to taxes, right? Getting a head nod in the affirmative. So the appropriate motion here would be that Senate File 1258 be recommended to pass and be re-referred to the Senate Committee on Taxes. Oh, wait, I'm sorry. Good thing I got counsel on top of things. There was still a concern about the effective date language on this, so that we don't run into any ex post facto questions about changing contracts that have already been, or settlement agreements that have already been entered into. So Ms. Primo has some suggested language to address that.
Mr. Chair, members, I'll read it, and it's as Senator Chair Latz explained. At page 1, line 13, before the period, insert "and applies to settlements entered into on or after that date." My understanding is this does not change the intent of the author, but it could potentially also have substantive effect. So I'm not going to say it's necessarily just a technical amendment.
Mr. Chair, I have no objection to that amendment. I'm wondering, and my question then would be, would there need to be adjustments made to lines 2.1 and 2.2, well, 2.2 as well?
Ms. Primo.
Mr. Chair and members, no, I don't think so, because that would affect the filing of the taxes after the settlement has already been signed and agreed to. It doesn't cause the same sort of potential contract impairment issue.
Understood.
So Senator Seeberger would treat that as a friendly amendment and moves that amendment as described by counsel. Any discussion by members of the committee? On the amendment, all those in favor say aye.
Aye.
Opposed, motion prevails. The amendment is adopted. Now the appropriate motion will be Senate File 1258 be recommended, as amended, be recommended to pass and re-referred to the Senate Committee on Taxes. All those in favor say aye.
Aye.
Opposed? Motion prevails.
Thank you
All
so
right.
much.
Thank you.
Thank you.
All right, we're going to change the order a little bit here. Senator Hoffman is here from outside the committee.
Thank you.
We are going to hand out fresh packets for this bill, members. It's the last item on your agenda. Rest assured, we are not going to be skipping the other items on the agenda, however. Senate File 225, carbon monoxide alarms. Senator Hoffman.
Mr. Chair and members, thank you. There's an A2 amendment for you.
Which is in the new packet that is being handed out, members. So we're going to wait until that's out to all of our members.
It is an author's amendment, Mr. Chair.
Is this your first stop, Senator Hoffman?
You know, Senator Chair Latz, yes. And you know, the first time I actually sat in front of this committee was over 10 years ago, and it was the National Cheese Puff Day, and I brought you cheese puffs, if I remember right. And today is actually National Assistant or National Staff Awareness Day or something in that aspect. So, but you had donuts earlier. When I was here at 9 o'clock this morning, there was donuts out there, so I'm sorry if it's the afternoon and I didn't bring you National Cheese Puffs, but I
That's
just
going to cost you, Senator Hoffman. It might cost you some support on the bill. No, I'm just kidding.
I will go down and get you some Dolly Madisons. I'll be right back.
I will confess that my staff failed to inform me that today was National Staff Appreciation Day or whatever it is, so I didn't even think to bring donuts for the staff. I should have. But the Senate took care of it for me, so.
Yeah, they did.
I
Isn't
guess.
that
So
nice?
we're all covered.
Thank you.
All right. So I see this first went to Labor but was withdrawn and re-referred to us. So we're the first policy committee to hear it. And Senator Hoffman would like the A2 amendment added as an author's amendment. Senator Umer Verbatim so moves. All those in favor say aye. Aye. Opposed? The motion prevails. The amendment is adopted. Senator Hoffman, to your bill.
Thank you, Mr. Chair, and thank you for putting this in the order that I'd like it to be in. Subdivision 6, I believe, is your only real jurisdiction when it comes to this, so I'm not going to bore you with 45 minutes of dissertation on why this is an important piece, but thank you for hearing Senate File 225 today. It's carbon monoxide alarm requirement modification for hotels and lodging houses. As you know, carbon monoxide poisoning is prevalent throughout the U.S. and underreported because CO detectors are not required to this degree in any state, and there's no requirement that injuries and deaths are reported to a government database. And so, for example, I can document at least a dozen carbon monoxide leaks in Minnesota hotels in 2018 and at least 16 in 2019 to 2020. But what I wanted to really get to is carbon monoxide poisoning leads to lifelong injury, if not death, for many who survive, Mr. Chair. And there's recent studies that you should have in your packet that shows a high correlation between carbon monoxide exposure and development of epilepsy, with the highest correlation being in young people. And what we're asking here, Mr. Chair and members, is that carbon monoxide detectors really cost about a penny a day to put into the hotels and lodging houses that we're talking about here. And now I turn it to my testifier, Leslie Linneman, who this is also personal to me because her son, and you'll hear the story, I happen to know Leslie and her family well, and I just want you to listen to what Leslie has to say in more detail. So thank you, Mr. Chair.
Thank you, Ms. Linneman. Before we go to your testimony, I just want to clarify what's before us here today. Members, we are told that there is no Labor Committee jurisdiction here because it's the Fire Safety Code that is being amended. So the entire bill is before this committee for policy purposes. So Senator Hoffman will be glad not to have to go to another committee if he gets the votes to pass it out of this committee, given his opening statement. But we will take the testimony and then we will consider the whole bill before us. Ms. Linneman, welcome to the Judiciary Committee in the Senate. Please go ahead.
Thank you, Chair Latz and members of the committee. My name is Leslie Linneman, and I am here today as a mom to ask you to lead this nation in protecting people from injury and death due to carbon monoxide exposure. And people believe that they know about carbon monoxide, and let me tell you from my personal experience, what you know is not enough.
When my son was 18 years old, my son is a hockey player, I'm a hockey mom, and when my son was 18 years old, I took him to a hockey tryout, and it was supposed to last for 4 or 5 days. We checked into the hotel, we woke up in the middle of the night with headaches. I gave my son medication, I tried to help him. The next day, he continued to have symptoms, his feet went numb while he was skating. I took him to a chiropractor who could not help. That next night, we both, again, woke up in the middle of the night ill, and again, not understanding why, taking, over-the-counter medication. But the third night, we both became so ill that we were dizzy and vomiting, and I realized that I was in trouble because I couldn't take care of my son, and he couldn't take care of me. So I drove to the emergency room, which in hindsight was probably not great judgment given my condition, but I didn't know what was happening. I didn't know that my brain wasn't being poisoned by carbon monoxide. And I didn't know because there wasn't a carbon monoxide detector in the hotel room, despite the fact that the hotel had had previous carbon monoxide leaks and had other injured guests. When we got to the emergency room, it took them an hour to properly diagnose us. The only treatment for carbon monoxide poisoning is 100% oxygen or being put in a chamber. Because it took an hour to get the blood test that showed that we suffered carbon monoxide poisoning, our treatment was delayed. And so I found myself in an emergency room in the middle of the night, separated from my child, being told that I had life-threatening levels of carbon monoxide in my blood, and so did my son. And I thought we had lived and we were going to be okay. But I was wrong. Because if you survive carbon monoxide poisoning, 40 to 50% of people suffer over the next weeks, months, and years of their lives serious physical, emotional, and neurological symptoms. And that has been the case with my son. My son has permanent neurological injury because I took him to a hockey tryout and I checked into a hotel and I didn't understand that there was no carbon monoxide detector. The study that came out a couple weeks ago shows that once you have suffered carbon monoxide injury, you are at a higher risk for developing epilepsy, particularly young people. And I ask you to think, having that knowledge sitting here today, how safe do you feel checking your child into a hotel? No state in the union has done what I'm asking you to do today. But it is important because carbon monoxide leaks are common in hotels and underreported, and we can't stop that. But we can prevent carbon monoxide injury by simply having hotels install carbon monoxide in individual guest rooms. Now, there have been arguments that they are not required in each guest room because not all guest rooms have appliances that are gas appliances. I gave you a list. There's a ton of data in that packet showing that carbon monoxide poisoning happens in hotels that have electric heaters. It happens from pool heaters, water heaters. In our case, it was a water heater that was in a maintenance closet across an open-air hallway that had not been properly ventilated. And the carbon monoxide found its way into our room and injured my son and myself. And our lives will never be the same because of it. Luckily, the emergency room doctor had the hotel evacuated before anyone died that night. But they would never have known it if we had not gone to the emergency room. I, since that time, have carried carbon monoxide detectors with me when I stay in hotels, and twice in Minnesota since that time. My personal carbon monoxide detector has alerted me to the presence of carbon monoxide when hotel carbon monoxide detectors were either not present or not alarming. This is a problem here in Minnesota, and people are being injured whether you know about it or not, and they will die. It is only a matter of time. Again, all the data I provided you goes through October of 2022, to the extent that we can collect data that is not required to be reported. You hear about it in the news all the time. what surprises me is that most people I talk to are shocked. And they say, it never occurred to me that there wasn't a carbon monoxide detector in the room. And it never occurred to me either. And so this is an important public health risk in the state of Minnesota. And it will continue to be until hotels are required to install carbon monoxide detectors. I personally do not understand the opposition to this bill. And because I don't understand the business reason why you would not want to protect your guests and your hotel employees and other personnel, events that, weddings, if you're having events in your hotel. One injury from carbon monoxide is far, far more expensive to a hotel's business, to their reputation, than the cost of a carbon monoxide detector. In our case, after we were injured, 3 weeks after, the hotel put a carbon monoxide detector in that room, and they've provided to me the cost. It was $35. If they had installed that $35 carbon monoxide detector 3 weeks beforehand, my son would not have suffered this injury. Carbon monoxide detectors now last 5 to 7 years. You can purchase them fairly cheaply. They are reliable. The batteries last a very long time. The business case for this is to protect people and not have these injuries cause either injury or death to hotel guests, but also injury to the business. I also wonder to myself, I know that there are a lot of small hotels in this state, but I also know the people of Minnesota. I've knocked doors along with all of you, and I've talked to them on their doorsteps. I can't imagine being the hotel owner who goes to work that day and realizes that a child has lost its life in the hotel that I own. I can't imagine that, and I wouldn't wish that on any hotel owner. Now, there are folks who have criticized me over the last several years as I've been advocating here and in the Minnesota House of Representatives for this bill, that I am emotional and I'm making an emotional plea, and that is certainly true. Who wouldn't in my position? But I am not asking you to make an emotional decision. I'm asking you to make a public policy decision as the representatives of the people of Minnesota, that within our borders here, people will be protected from carbon monoxide injury and death. Please support this bill.
Thank you.
Thank you, Ms. Lindeman. And I'm going to apologize for the comments of levity that I made in the bringing up the bill here. This is obviously and appropriately a very serious and emotional topic for you, and your family has suffered a serious loss. And so I don't want you to interpret in any way that the jokes that we were making as we were getting into this bill here now had anything to do with the substance of the bill or the situation that brought you here before us today. So we are so sorry for what you're going through and for the harm that you and your family have suffered as a result of this.
Thank you, and I'm absolutely not offended. It's been a long day for everyone here, and I understand that sometimes a break needs to clear the air of heavy subject matter that we've been dealing with all day. I've been here and I've listened to the seriousness of each of the bills that you've presented.
Thank you, Ms. Lindeman. I do have on our list Jill Sims from Hospitality, Minnesota.
Tony Quillis is here. She's gone.
All right, Mr. Quillis is going to come forward and testify in Ms. Sims' stead. Mr. Quillis.
Mr. Chairman, members of the committee, unfortunately, Ms. Sims was called away, but for the record, my name is Tony Quillis, and I'm representing Hospitality, Minnesota before you this afternoon, Mr. Chairman. I want to thank you for the opportunity to comment on Senate File 225, and Mr. Chairman, we appreciate the opportunity to speak on the Senate file. Hotel and lodging operators work diligently to ensure the safety of all of their guests and employees, in particular through adhering to the state fire code. Traditionally, the state fire code is revised and adopted through a rulemaking process, and just recently in March 2020, the state fire code was updated to require carbon monoxide detection in hotel sleeping units
where there are fuel-burning appliances or if they are served by fuel-burning forced air furnaces. A fancy word, Mr. Chairman, for fireplaces. Currently, the state fire marshal inspects all the hotel for fire compliance on a 3-year cycle, ensuring that just over 1,000 properties are safe for guests and their employees alike. Mr. Chairman, the bill does not specify what entity would enforce the requirements, Mr. Chairman, and look forward to working with the advocate and Senator Hoffman in addressing that, Mr. Chairman. And then we're operating under the assumption that the state fire marshal would inspect and enforce, and we believe the current penalties as described in the bill aren't aligned with what is a typical enforcement of the fire code violations for violating lodging establishments, Mr. Chairman. And we'd like to work with you and Senator Hoffman as we kind of move through the budget process to ensure that the state fire marshal has adequate staff and ability to conduct these additional inspections. Mr. Chairman, we'd also like to ask for some consideration on the timeline. There is about 87,000 hotel rooms in Minnesota, and so just trying to make sure that all of those hotel rooms have the opportunity to meet this requirement as it would move onto hotels and the lodging establishments. Make sure that supply chain and the adequate budget and availability for labor, if there's some small installation, Mr. Chairman, to make sure the supply is there. And then lastly, on the definitions of hotel, there are new definitions of hotel, Mr. Chairman, in Section 1 under Subdivision 11 and Subdivision 12, and there are existing definitions of lodging establishments found in Minnesota Statutes 327.70. So just wanted to point that out, Mr. Chairman. Look forward to working with Senator Hoffman to work through some of these concerns and with you to make sure that the State Fire Marshal's office is fully funded if this would so move forward. Mr. Chairman, and thank you for the time to comment on Senate File 225.
Thank you, Mr. Quillis. Any other public testimony to be provided here? Anyone want to testify? I'm not seeing any, so I got a couple of questions to follow up on that, if I might. Mr. Quillis, first of all, if there are some suggestions that you, for language to make this work, that you have that might improve the bill, have you had an opportunity, or maybe not yet, to talk with Senator Hoffman about that?
Mr. Chairman, members of the committee, Senator Hoffman has been very gracious with his time as we walk through some of the concerns, but I can't comment if Ms. Sims has language or not, Mr. Chairman. I apologize for that, but I think the definition of the lodging house and hotel, like I said, is found in 327.70. So that would probably be helpful there, and then I can check on the timelines if there is a preferred timeline for the effective date to allow hotels to meet this new requirement, Mr. Chairman.
Is that where these came from?
Is it covered? Were you here for this?
That would be the new, I think that's
fire
for
code
the
inspections.
hotel. When they go through to do that, it crosses it into this.
Yeah. Right. Yeah. Public safety said that was the okay.
Yeah, that's theirs, I think, isn't it?
Yeah.
So I've got a thought on approaching that, Mr. Quillis, but one other question. We do have a fiscal note, members, in our packet, which shows no fiscal impact, and I'm reading it, and I can't tell for sure if the State Fire Marshal's office specifically weighed in on it. There's an assumption in here which says that they do the inspections, but I can't tell from the note here whether or not they were asked as a division specifically to indicate if this bill would add any work on their part. Or maybe they already inspect every hotel room
They do every 3 years.
for fire alarms or smoke alarms, and this would not be any added burden. Mr. Turner, if you could maybe take a moment to look that up. With regard to the definitions in here, There's a definition in the fire safety code already of hotel and lodging houses, which is different than the code that Mr. Quillis referred to at 327.70. It's much more close to what's in the bill here, and so council is taking a look right now at what the comparisons are, and it might be easier, unless these were redefined some way specifically for a purpose for this bill, it might be easier to simply cross-reference the definitions that are already in the fire code. So we're going to look at that. I don't want to get into a rewrite of the bill here when the stakeholders might be able to do that offline, but if these are fairly simple fixes, we could do that now. Otherwise, I'm inclined to, there's probably not going to be a longer fiscal process for this to go through, is what it sounds like. So it might be this committee here and now, or come back to this committee at a later hearing. Mr. Pappas, have you had a chance to take a look at the definitions?
Mr. Chair and members, before the bill was heard, I did see that both hotel and lodging house are defined in Chapter 299F. The definition of lodging house in the bill is identical to that definition. The definition of hotel is identical, except the 299F.391 definition also requires that they be licensed pursuant to Chapter 157. So one thing you could consider doing is just cross-referencing those definitions, which are something that presumably the fire code people are familiar with because it's already in statute. I don't know if Senator Hoffman would support that or not. The other definition that Mr. Quillis mentioned is, I'm just looking at now, it's a completely different definition in Chapter 327. And I think it would be substantively different, but I could look at it more if you'd like.
Well, I'm inclined, especially as the fire marshal is going to be the one enforcing this, that we work with a definition they're already familiar with. Mr. Quillis, what do you think about that?
Mr. Chairman, I think that we were drawn off, as Mr. Pappas referenced, the 327.70, where hotel is defined in there. It's also, Mr. Pappas mentioned another one. I think the hotel definition in Senate File 225 just was talking about 6 or more, so it would not include smaller ones. But I think, Mr. Chairman, if you just use whatever one the chairman and Senator Hoffman decide they want to use, Mr. Chairman.
Senator Hoffman, what do you think?
Mr. Chair, I once played a lawyer in a play, but I'm hearing from Mr. Pappas, there is a reference to 157. I wonder if in lines 1.10, does that cross-reference 157.01 and to 157.22? Is that all captured in there?
157, where are you getting?
Well, that, Mr. Chair and members, that was just on the 299F, then there was there's Chapter 157. There's a reference to the fire code that Mr. Pappas said that. Just I wrote that down. Maybe you could reemphasize that for us.
Mr. Chair, members.
Mr. Pappas.
Yeah, to clarify again, the bill, Senate File 225, has an identical definition of lodging house to 299F.391. And the definition of hotel is also identical to that definition in that same other section, except 299F.391 also has a requirement that the hotel definition there refer to those that are required to be licensed pursuant to Chapter 157. So there's one additional requirement in the other 299F definition that's not present in Senate File 225, and that's the requirement that the hotel be licensed pursuant to Chapter 157.
Mr. Pappas, or maybe I see Ms. Sims has returned. Maybe we can get an answer.
Mr. Chairman, I'll probably let her come up, but I've been also informed that 327.70 is the hotel licensing statute, so that's why I referenced it in the testimony.
Okay, and then my question would be whether or not all hotel rooms are licensed, or at least those that contain 6 or more guest rooms. Ms. Sims, if you want to come forward. Go ahead and identify yourself.
Thank you, Mr. Chair. My name is Jill Sims, and I'm the Director of Government Relations for Hospitality Minnesota. I apologize, I had to sneak out to a meeting in the West Metro and hustle back. So the reason we referenced 32770 in our testimony, Senator Marty has a bill in terms of hotel licensing, and as we've sort of discussed already in committee, there are various definitions used throughout statute and rules for the definition of hotel. So trying to move to more continuity, and that also includes vacation rentals, I believe, in the 327. So we'd like to see, that requirement extend to all sleeping, that requirement apply in terms of equal playing field for hotels and vacation rentals.
So Ms. Sims, you're saying this, the definition in 32770 is broader than the definition proposed in the bill?
Correct, and it is the, I'm blanking on the number of Senator Marty's bill in a different committee, but is pertaining to hotel licensing, that he is working on a bill, and the definition that he is working with in statute is the 32770, which is the one we referenced in our testimony. So we're trying to.
Do the fire marshals inspect or enforce the facilities in the broader definition of hotels? Do you know? Or is anyone here from DPS that might know?
I don't know if DPS is still here. I believe, I can tell you confidently that Minnesota Department of Health enforces on 157. Is it 9-1 or 7-1? I forget. Health Department works off of 157. I can't speak confidently to fire marshal. They may be using the same.
Members, I am inclined to not try to figure out the interplay between Senator Marty's bill and this bill, which has its own specific definitions, and the closely related definitions elsewhere in 299F here today.
Thank you.
So what I'm going to suggest, and the fact that the idea is to look to the fire marshal to or anticipate the fire marshal is going to be doing some enforcement or inspection, but understanding the purpose of the bill would presumably to be wanting to capture all places where guests stay and someone else is the landlord and they don't have.
May I offer a historical perspective?
Very briefly, Ms. Lindeman. I'm about to say we're going to lay this over and let the stakeholders sort out the language and come back so we can do it right, rather than end up with a conflicting bills or provisions with another bill that's moving.
This language is the bill that is the same language that was passed through the House a couple years ago, and the definition was modified because there was some concern that there was concern about including vacation rentals, Airbnb and VRBO, that kind of thing. And so that's why the language exists here in this proposal. It's identical to the House proposal.
So thank you. That's helpful. But I think I don't want us to make a decision here and now about which language is going to be best. I think, Senator Hoffman, it's your bill.
Yep.
I mean, we can follow your guidance. If you'd like us to make a decision, we can just pick one and move it forward. If you'd like to talk with Senator Marty and with Hospitality Minnesota and the fire marshal and figure out what the best route forward is, you're welcome to do that. I don't want this modification to end up being made on the Senate floor, however. So if we send it out and everyone else comes back and says, no, it really should be something else, I'm going to ask that it come back before the committee with policy jurisdiction rather than fixing it on the floor.
Mr. Chair, I actually agree with you, and because this is been vetted twice in the other body, I will not say what it is, since those folks that served in the other body vetted twice. That language was in there. This discussion occurred. It is my prerogative that it would stay closely related to what's already traveling. I don't know if Senator Marty's bill is traveling at the same way. I mean, there's 4,000 bills out there.
But let's assume that it does, Senator Latz, then it is this committee's lifelong love to look at Senator Marty's, if it would make it past that mark, and this one to just line up those. You remember, you ever heard the conversation about me lining up the beans in the kitchen cabinets? You know, you line up. That's what statutes should. They should line up. The beans should line up with the beans, the corn with the corn. And in this case, we don't know where Senator Marty's bill is, but we do know where the other body's bill is on this.
We do know where Senator Marty's bill is, Senator
Oh, you
Hoffman.
do? Tell me.
It's been heard in state and local government and laid over for possible inclusion.
So eventually you're going to have, Mr. Chair, may I? You're going to eventually have a conversation about how that interacts with the bill that is already passed the House and then this bill. So.
Well, someone may have a conversation. Unfortunately, sometimes ships pass in the night around here, and we could end up with, this bill could go on its own, become law with one definition, and that bill could go on and have a different definition, and it might not work all that well together. So what is your preference, Senator Hoffman, as the chief author? Do you want us to leave the definitions as they are? Would you prefer that we cross-reference existing definitions? Understanding that either way, they would be leaving out apartments, you know, and or guest houses, Airbnbs, those kind of things that might be in a broader definition in Senator Marty's bill. What would be your preference as the chief author?
My preference, Mr. Chair, is to keep it consistent with what we know happened in the House with this specific bill. So that would be my preference.
Okay. And then the only other question, well, I guess it'd be up to the committee whether we wish to do that. If there are any amendments, people should think about that. But the other question that I had to do with the safety warning in subdivision 6, because Mr. Quillis raised a question of that, the penalty alignments with other penalties. I didn't quite follow the detail of that. I'd be interested to hear more about that. Honestly, I see a first violation as a safety warning, a second or subsequent as a petty misdemeanor. I'm wondering if at some point repeat violations shouldn't become a misdemeanor, but I'd be interested in hearing about that. Senator Hoffman, chief author, what are your thoughts on that?
Mr. Chair, I'll never forget, 10 years ago, you and the good Senator Newman and Warren Limmer got into a debate over should it be a misdemeanor, a gross misdemeanor, or a felony. And I sat back and I watched for 3 hours you guys have that discussion. And so if you believe it should be where it's at, I'm going to trust your expertise in discussion. Not that I'd like to relive that, but it was to have a front row seat. I absolutely, no, folks, it was absolutely enjoyable because I sat back and I watched, sausage being made in front of us. But for what is a standard this, standard that? And so
Senator
if you think
Hoffman,
the standard is there.
I can assure you we're not going to be here in 3 hours on your bill. Unless we lay it over and tell you to work on it and promise to bring it back at the end of our agenda, then we could make you stay.
No, I have a $2 billion budget to go through. And
for what it's worth, I'm informed that the companion bill has been heard in public safety and has been re-referred to the other body's labor committee. So it's not out of the committee structure yet in the other body. Ms. Sims, did you have a comment or suggestion regarding the safety warning provision here?
I do, Mr. Chair. We raised this as, and I'm looking at this further amendment. Again, I apologize for sneaking in a little bit late. To address my earlier statement, I think the fire marshal is subject to that 157 definition based on this language I'm seeing here. And when you have a fire code violation as a hotel, I believe their process is different than the one that's prescribed in subdivision 6. And so we would like to see consistency that if you have a violation, if you're a hotel operator, you can know what to expect and go through the same due process if it's a violation in relation to potentially this bill passing or any other existing fire code. So just continuity.
Ms. Sims, what are the penalties for a fire code violation?
I believe the first violation is a warning, and then the second with a window to
fix the problem, and I do not recall off the top of my head what the second is.
I think I would like to know that before deciding whether that's a good penalty provision for this bill.
I do have the answer from DPS somewhere in my email, but I don't think I have that printed in front of me. And again, I apologize, shuffling between events this afternoon.
So I'm going to assume that the chief author would prefer a robust rather than a less robust consequence for repeat violators of this provision, but I certainly would. But I'd like to know what we're comparing here. So council is busy, I'm sure, trying to figure that out as we're sitting here. So I think what we're going to do, I don't see anyone jumping up with the answers at the moment. Ms. Sims doesn't have a direct answer. Council doesn't have a direct answer. Senator Hoffman, I know, has another commitment somewhere else. Don't know if you want to have us do one other bill, come back with some answers for this tonight. I'm not inclined to act on a bill I don't have all the information on. So, and I still don't have a confirmation from fiscal. I would assume the fiscal note that was raised by Mr. Quillis. I think we can rely on the fiscal note that says zeros for now safely, and our legislative budget office has already given its stamp of approval, whatever their process was. So, Ms. Sims, do you have an update for us?
So the information I have is on a violation would be given for a deficiency in statute of code, and then there would be a follow-up inspection once the owner of the facility came into compliance. So that is how existing fire code is managed, and we are asking for continuity.
But no penalties for failing to come into compliance? No fines or administrative sanctions? No?
My request into the fire marshal's office did not go into as much detail, so we would probably need to hear further from their office.
Yes. I think we should. Mr. Backus, have you uncovered anything to share with us? Senator Limmer, do you have any illumination here? Any light
I do
to add
not.
to the
I had
smoke?
a different reference to remind the author, maybe he could get an answer for me on.
Senator Limmer.
On the author's amendment, you made reference to a statute 299F.51. I looked it up, and it makes reference to single-family dwellings and multi-family dwellings, and yet it's in your amendment under a subdivision regarding hotel inspections. And I was wondering why a residential multifamily or a single dwelling reference on carbon monoxide alarms is in that provision. I don't know if it's expanding the scope of your bill into residential construction. Residential construction, as you might be aware, has statute referring to required carbon monoxide and smoke detectors. So I was just wondering, maybe offline you can tell me why you wanted that in this area of law.
Mr. Chair.
Senator Hoffman.
Thank you. Thank you, Senator Limmer. And that actually, the Department of Public Safety, after they had looked at this was their technical assistance, and they wanted to clean things up within that piece. And so this A2 amendment came directly from our Department of Public Safety and this division of the fire code people. So that's where it came from.
Mr. Chair,
Senator Limmer.
could this be perhaps reference to perhaps a boarding house or a sleeping room or a Airbnb unit inside a bigger house? I don't know, but before it gets to the Senate floor, maybe you and I can get an answer from Public Safety why they wanted that particular provision of statute in this area of law. We can work on it.
Oh, absolutely. Mr. Chair.
Senator Hoffman.
Senator Limmer, absolutely. Thank you for that. Yeah, the Department of Public Safety, when they looked at it, they said, we just want to make things consistent here. So it's a great follow-up piece to that. Specifically, did it pertain to this? My assumption is no, it didn't pertain to that, but rather it drew us into the state relating to, and that word relating, that's where I think it draws us back into the relating to. Again, I'm not a lawyer. I played one once, Senator Chair, but I think that's what, if you read that, that's what it draws to. That's what I'm getting on that one, Senator Limmer. So,
Senator Cruin.
Thank you, Mr. Chair. I think I agree with Senator Hoffman on that. I think it's the relate to, so it's kind of giving how the inspection, how the fire marshal inspects those other types of situations. That's my reading of it. Thank you.
thank you. That's, yeah.
Senator Hoffman, what would you like us to do with your bill?
I would like you to do, Mr. Chair, is to, was it your desire? I mean, we thought it was going to go to labor and industry, but you reminded us that because of the fact that now our wonderful friends at the Department of Public Safety have said this is what we want to have in here, it looks like it stays here. Are you doing an omnibus bill, Mr. Chair?
We are not going to do a general omnibus policy bill for the committee. We might have some smaller ones that are focused on specific topics, but not overall. So if this is a policy bill, I just got a note from DPS that relating to the fiscal note that it is correct. So if it's part of the normal fire inspections, then there is no additional fiscal impact for them. So if we have before us the bill with the definitions of the covered proceedings, the requirements for the owner to do what they're required to do, and then the penalties for violations of a safety warning, and then a second or subsequent is a petty misdemeanor, which means it could be a fine of up to $300. So if it's the desire of the chief author to leave that penalty provision, then I think that'll be the provision we have before us unless the committee wants to make a change. Do I see anyone interested in doing anything more with the bill? All right, then Senator Hoffman, the next stop will be the Senate floor. Is that where you would like it to go?
Mr. Chair and members, although I would love to see a 3-hour debate on making, I'm kidding. That's, yes, Mr. Chair, I'll be sincere. Yes, yes, Mr. Chair.
We'll send you the recording of the next 3 hours of the committee for your enjoyment, Senator Hoffman. Senator Pappas, I am informed, is willing to move the bill.
Thank you, Mr. Chairman. I'd like to move that Senate Bill 225, as amended, be recommended to pass and sent to the Senate floor.
The motion is clear. All those in favor say aye. 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 Opposed? The motion prevails. Senator Hoffman, head on home to your family. Ms. Linneman, thank you for being here today. Ms. Sims, thank you. Mr. Quillis for your testimony.
Mr. Chair and members, thank you. Thank you.
All right. Well, let's get this one done because that's.
I could see a repeat violation being done or fine. But could always be next session. Yeah, or floor amendment on the floor last meeting. And he'll get it.
No, he was very clear. He didn't want the definitions dealt with on the floor. He didn't say penalty.
Three more to go.
Senator Latz, we have Senate File 1448 before us. You may begin whenever you're ready.
Madam Chair, thank you. Senate File 1448 makes some clarifications in statute about the ability of individuals to retrieve contents of their towed vehicles after they have been towed to an impound lot, especially even if they do not intend to find a way to get the vehicle itself out of the impound lot. To testify in more detail, I have Ron Elwood from Legal Aid. I'd ask the court to hear the testimony. I'd ask the committee to listen to Mr. Elwood.
Mr. Elwood.
Thank you, Madam Chair and members of the committee. Ron Elwood with Legal Aid, and thank you, Senator Latz, for carrying this bill. Very simply, in 2008, this legislature passed an important bill to allow indigent car owners to retrieve the belongings in their car from a tow operator, even if they had the inability to pay for the tow costs. We had so many instances of operators withholding medicine, wheelchairs, kids' clothing, kids' homework, et cetera, et cetera, et cetera. And we had arranged with the Minnesota Towing Association to allow those clients to get their stuff. All these years later, we've had multiple cases in which not all, but some tow operators were simply not complying. And there was no remedy in 2008, and this bill puts in a remedy essentially allowing a person who is aggrieved to seek a court to compel compliance, and if they throw the belongings away after the period of storage is expired, there is some compensatory opportunities here, and that's as simple as this bill, and we appreciate your support.
Thank you, Mr. Elwood. Members, do you have any questions or comments?
Maybe you want to mention we have support from the Towing Association.
Madam Chair,
Senator
I want
Latz.
to call to your attention, I believe this is in members' packets, there is a letter from the Minnesota Professional Towing Association that they support this bill.
Thank you, Senator Latz. If there aren't any questions or comments, if you'd like to move the bill.
Madam Chair, I move that Senate File 1448 be recommended to pass and be sent to the Senate floor.
Senator Latz recommends that Senate File 1448 be recommended to pass and sent to the Senate floor. All those in favor say aye. Aye. Any opposed? All right, it's being sent to the floor.
Thank you. Members, may our next two bills go as smoothly. Members, we have people who have been waiting all day to testify before this committee on the next two items, and although I would prefer to end our day now, I think we're not going to tell them to go home and come back another time. That would really be unfair to them. So I'm cognizant that it's 4:40 Friday afternoon, but that said, I'm just going to ask members to consider the time of day and as you determine how you approach questions and debate for these bills. I'm not going to cut anyone off unnecessarily, which leaves me a little bit of discretion to do it. But I'd rather not see discussions stray into lots of side tracks that aren't focused on the content of the bill. So we are going to continue in order on the agenda here. Senate File 1478, Senator Umu Verbaeten on the felony murder proposal. And the testifiers for that I have listed are Claire, is it Deagle?
Yes.
And Perry Moriarty and Tony, I think it might be misspelled here, Cater or Carter? It's Cater, C-A-T-E-R? Okay, so we'll have the first two, Ms. Deagle and Professor Moriarty, come on forward. And since my vice chair is now sitting at the table, Senator Limmer, would you do the honor of carrying the gavel during the initial presentation while I take a short break? I know you're capable. Thank you.
All right. Senator.
Thank you, Mr. Chair. Thank you, everyone, for being here. It's been a long day, but this really means a lot to the families who are here with us. And I also want to thank our staff for all of their work in preparing the latest amendments. Today, I'm presenting Senate File 1478, or felony murder law reform, which seeks to reform the felony murder aiding and abetting law. Currently in Minnesota, people can be charged with and convicted of murder even though they did not kill anyone, did not intend for anyone to die, and did not anticipate a death would occur. This is because of our current aiding and abetting homicide laws that too often ruin the lives of people who intended no harm by their actions. In 2021, a bipartisan legislative task force was formed to examine Minnesota's aiding and abetting felony murder doctrine, compare it to other states, and look at patterns in who is charged and punished under the doctrine. This task force included county attorneys, police chiefs, victim advocates, impacted people, public defenders, and other experts. Their recommendations were to revise relevant statutes to limit aiding and abetting felony murder liability, to revise relevant statutes such that people previously convicted of aiding and abetting felony murder may petition the court for relief, and to implement reforms beyond mere adoption of an affirmative defense for aiding and abetting felony murder. Existing law allows aiders and abettors to be charged with murder and has disproportionate impacts on our population. 48% of people charged are Black, 80% are people of color, and 63% are people charged under the age of 25. The majority of these people have little or no criminal history, and clearly the law as is not, as written, does not serve as a deterrent. Simply put, here's what this bill aims to do. It aims to limit the charge of murder to those who actually commit a murder, aided and abetted a murder, or acted with extreme reckless disregard for human life. It also aims to allow those serving under current law to apply for resentencing and be held accountable for the crimes they committed, not the crimes of someone else. And it aims to not trap innocent people or those just in the wrong place at the wrong time in our criminal justice system. You're going to hear more about how this happens. But in summary, this proposed legislation strikes the right balance on how primary actors and those with lesser involvement are treated by the law. It's, I believe, just the right thing to do to ensure fundamental fairness, effective law enforcement, and ultimately public safety. And again, I really want to thank the felony murder law reform group, especially Tony, the families who've been impacted by this. They've really turned a personal tragedy in their life into just an amazing movement, and have never stopped giving up on this fight. I also, want to point out that we have bipartisan support. I want to thank all of my co-authors, Senator Mann, Senator Westland, Senator Pratt, and Senator Duckworth for supporting this bill. And with that, I will move to the testifiers.
Thank you, Senator.
Yes, Mr. Chair, there's a delete all amendment to get this bill in the right shape. Yes, Mr. Chair.
Senator Uma verbatim.
Yes, Mr.
I
Chair.
hope first time I ever said that. So moves the A6 amendment. It's an author's amendment. All those in favor say aye.
Aye.
Opposed? The amendment is adopted. Senator, who would you want to have give testimony first?
Thank you, Mr. Chair. I'll let Perry to my right start.
That's okay.
Would you first identify yourself for the record and then proceed with your testimony?
Yes, Senator Lemmer, thank you. Chair Lemmer, my name is Perry Moore-Yurdy. I am a law professor at the University of Minnesota. Thank you very much for allowing me to testify today. In conjunction with my work as a law professor, my students and I have represented clients who have been impacted by the laws that we're discussing today. And I've also researched and written about both the aiding and abetting and felony murder doctrines. I, along with Claire Deagle of the Minnesota ACLU, am here to discuss the genesis and the major components of Senate File 1478. But to be honest, Senator Uma-Verbeten's, your summary stole a lot of my thunder. A lot of what I was going to say, she's already said and said it very well. So I'll try to condense my statements here. Let's see if I can forward this here. Okay. So I'm going to discuss the evolution of our task force. I was a member of the task force, and Ms. Deagle was as well. And Ms. Deagle will talk about the task force recommendations and the specific components of the bill. In June 2021, the Minnesota legislature established the task force on aiding and abetting felony murder. And as you can see, the members were truly bipartisan. They represented a variety of different perspectives and a wide range of offices. And the mandate was clear. We were to look at Minnesota's aiding and abetting felony murder laws from every angle and the laws of other states. The impetus for the task force was fundamentally about both the efficacy and inequity of Minnesota's laws. And the data we collected from the Minnesota Sentencing Guidelines Commission and other sources bore this out. People charged with and convicted of aiding and abetting felony murder in Minnesota are disproportionately Black and brown. In fact, 80% of the people charged with aiding and abetting felony murder in Minnesota between 2010 and 2019 were people of color. Nearly half were Black, in a state that is just 7% Black. People charged with and convicted of aiding and abetting felony murder in Minnesota are also disproportionately young. 63% of those convicted during the same period were under 25, at an age when we know their brains are continuing to develop in really pivotal ways. There are also significant gender disparities. I don't believe they're reflected on this slide, but 12% of those statewide convicted of aiding and abetting felony murder self-identify as female. And that percentage is quite a bit higher than the percentage incarcerated for non-aiding and abetting felony murder offenses. 42% of those convicted were in just one county, Hennepin County, which suggests that geography may also play a disproportionate role in the application of the laws. Finally, the imposition of the punishment themselves was disparate. The aiding and abetting and felony murder doctrines have long been controversial in this country and internationally for one basic reason. Their convergence allows a person to be charged with and punished for murder without ever intending to kill or even harm another person. This violates one of the criminal law's fundamental principles, that a person should be held accountable for the harm they intended and punished in accordance with their culpability. To do otherwise is fundamentally unfair and unjust. It is this inherent unfairness that has led every common law country in the world, but the United States, to abolish felony murder. England, Ireland, Canada, Australia, and India. It has also prompted 4 U.S. states to abolish felony murder and many others to do what we are now proposing. Limit homicide liability to those who intended or were major participants in a homicide. Finally, the impetus for the task force is the expansive liability that Minnesota Statute 609.05 already contains. In its current form, it purports to punish intentional aid, and I apologize, I'm realizing that, oh, I guess we do have our slides here. I thought we hadn't. Here is 609.05. It purports to punish intentional aid, but the interpretive case law says that knowledge is enough and that active participation in the overt act of homicide is not required. When this law is combined with Minnesota's felony murder laws, it means that someone like 16-year-old Jamesia Donnerson and 19-year-old Megan Cater and Brianna Martinson, who you will hear about in just a minute, can be charged with first-degree murder in the state of Minnesota, even though one was just sitting outside in a car when a homicide occurred, and the other 2 were lying face down at gunpoint when an adult male took the lives of their victims. This should not happen, and this is what we seek to end.
Mr. Chair,
you.
I'd like to move to my next
Senator.
testifier.
Yes. Would you identify yourself for the record and then
Yes.
proceed?
Thank you, Mr. Chair. My name is Claire Deagle, and I'm a staff attorney at the ACLU of Minnesota. In that capacity, I was honored to serve as a member of the task force on aiding and abetting felony murder. The senator already discussed or already mentioned the task force's 3 key recommendations, so I'm just going to touch on how the legislation in front of all of you incorporates those recommendations. First, SF 1478A6 limits first-degree murder liability to those who caused a death or aided and abetted with the intent to cause a death of a human being. So this means that liability for murder would only attach in those specific circumstances for first-degree murder. For second-degree murder, the legislation limits liability, again, for the murder, to those who caused the death or were a major participant in the underlying felony who acted with extreme indifference to human life. Both of these provisions ensure that convictions are commensurate with the person's individual culpability and resolve the wide-ranging disparities that Professor Moriarty already spoke about. These and then the final reform I'd like to touch on here is the provision that allows for retroactive relief. Allowing for retroactive relief is the only way to ensure that an individual receives a conviction and a sentence commensurate with their culpability. And again, it is the only way to resolve the disparities that we know exist because of the current state of the law. All of these provisions and the disparities that they seek to address have been vetted and approved by victims groups like the Minnesota Alliance on Crime, which is a statewide victims' right and advocacy membership coalition, as well as Violence Free Minnesota, a statewide coalition working to end relationship abuse with 80 member programs providing services to victims and survivors in 87 countries. I'd like to briefly touch on the definition of major participant that is in the legislation before all of you today. The term major participant, as it is used here in the second-degree murder provision, has origins in U.S. Supreme Court cases from 1982 and 1983. In those cases, the court was discussing a spectrum of culpability for felony murder. And the court ultimately decided that a major participant who acted with reckless indifference to human life, while not on equal footing with the person who actually caused the death, was still culpable. California recently reformed
its laws on aiding and abetting felony murder, and they also adopted this Supreme Court language. I also briefly want to touch on the provision for retroactive relief. Specifically, that provision allows for those who were charged with aiding and abetting felony murder and thereafter convicted of first or second degree murder. It allows for them to petition the court to first submit an application, but then petition a court so that they could be subsequently sentenced under these specific provisions. And the legislation explains exactly how that would happen, and we're happy to answer questions about that. But that is a key piece of this legislation, and again, had bipartisan support from the task force.
Mr. Chair, I'd like to bring up my next testifier.
Would the next testifier come up to the table? And would you identify yourself for the record and then proceed?
There's a different face in the chair spot than I expected. So, Chair Limmer and Senators, my name is Toni Cater, and I'm the co-founder of FMLR and the mother of Megan, an impacted person under aiding, abetting, and felony murder. We began our journey into learning of the aiding and abetting and felony murder laws when Megan and Brianna, her best friend, who were 19 and 20 at the time of their tragedy, they were both victims of rape in high school, which led them to self-medicating their trauma. That spring, they were both deep in their substance abuse when they agreed to go with a couple of high school friends to retrieve some items that had been stolen from Brianna and one of the other friends. One thing led to another, and one of those young men decided to bring a friend, and he brought a 33-year-old acquaintance who brought a gun. The girls ended...
Could you pull your microphone closer? Thank you. Sorry to interrupt you.
That's okay. The girls ended up having their lives threatened by this man, being told if they screwed anything up, they would be killed. And then they were forced to lie on the floor, face down in the apartment, and watch their friend beaten and then shot. The girls were and are still terrorized by the memories of this night, and they both suffer from constant nightmares. Their hearts and our hearts go out to the family of the young man who lost his life that night and his girlfriend who suffered those horrors. The girls could never have imagined this was going to happen. Megan and Brianna, the two young men who never left the car, and the two men who beat and then murdered this young man, all received the exact same charges of first-degree felony murder. What we now know is this has been common practice. Megan is now 24. And her and Brianna are 5 years into their 13-and-a-half-year sentence. Megan and Brianna continue to amaze me as they take correspondence college courses, educate themselves on trauma reduction. In fact, Brianna is the mentor for new women who enter Shakopee Women's Prison, helping to teach them and support them upon entry. And my Megan has recently been a facilitator for a book club on trauma. Most of the women are long-termers who have been there and are twice her age. They pray, they host Bible studies, all while surviving over 3 years of COVID protocol, which has constantly left us unable to visit them. These two young women count and can count on you, their lawmakers, and continue to have hope. Hope in this system, hope in their faith, and hope in you. Today, we were supposed to have a special young woman with us who Perry Moriarty spoke about. She wanted to be here to testify, but she is currently 8 months pregnant, and the emotional toll of retelling her story is too traumatizing on her and her unborn child. She did testify earlier this week in the House and is now resting. She has given me permission to share her tragic story, so let me introduce you to Jamesia. My name is Jamesia Donnerson, and at the age of 16, a situation occurred in my home where I felt I was no longer safe to live there. I then turned to the streets for comfort.
During that time, I started dating an adult male. This adult male murdered someone in an apartment building while I sat in the car. I did not know the victim, nor did I ever see the victim's face. From that point on, my 16-year-old life changed. I was charged and convicted of murder when I never murdered anyone. I was sentenced as an adult, but I couldn't be around adults due to my age. Therefore, I was kept segregated in my cell 23 out of 24 hours a day because I was in an adult facility. This took a toll on my mental health. I never understood how I was charged and convicted as an adult, but I was kept away from the adults. I was sentenced to 12 years. During my incarceration, I had to figure out how to become an adult. I got my GED, took college courses, and got my paralegal certificate, only to discover once I was released, my paralegal certificate wasn't of any use due to the school not being accredited. I also faced challenges of getting an apartment and jobs due to being labeled as a murderer. No matter how much you try to explain to the employer or a landlord, it says murderer on your background, but you never murdered anyone. They don't believe you because you are what they say you are in your background check. After serving my time in prison, I thought for sure I would live a normal life. Until this day, 15 years later, I'm still punished for a murder I didn't commit. I'm now starting a family and recently tried to get life insurance and found out the company wouldn't accept me due to being a convicted murderer. 15 years later, I'm what you call a productive adult. I have a job I love, a place I call home, I pay my taxes, but somehow I still get punished for a bad choice someone else committed 15 years ago. When will the punishment ever stop? Please change this law. Every day I have to prepare myself to explain how I'm not what it states in my background. I am Jamesia Donnerson, a human who's trying to live a productive life. Senators, I am here as an impacted mother and the co-founder of FMLR. What I know is Minnesota is not safer with Megan or Brianna in prison. It was not safer with Jamesia in prison, nor Crystal or Louise or Nikki and so many others who are locked up for extensively long sentences for murders they did not commit. Today I'm asking for you to support this bill and moving it forward and changing these draconian laws. Thank you.
Thank you for your testimony. Senator, did you have anyone else to give testimony?
No, thank you, Mr. Chair. I would invite Ms. Moriarty to come back up to the table, and we're more than willing to answer questions from the committee.
Is there anyone in the audience who wishes to speak for or against this bill?
So let's open up the floor to the committee for discussion. Any questions, comments, concerns members of the committee wish to express? Senator Limmer.
Mr. Chairman, as I was listening, we've had a task force report created. A lengthy time has elapsed. And the reason why you want to extend the task force for another report, is it focused just on the liability issue, or maybe you could justify why we need yet another report?
Professor
Senator
Moriarty.
Latz, Chair, Senator Lemmer, thank you for the question. In part because we were able to work with a certain amount of data, but not everything we'd like to work with. So the data we had from the Sentencing Guidelines Commission covered 2010 to 2019. And some of the things that we saw when we went through that data involved sort of permutations of these laws that might have been reflected in data as convictions for something different in some cases. There were other manifestations of the aiding and abetting laws that implicated laws even beyond these. We're not looking to expand the mandate in a pivotal way.
we would just like to reconvene. And I don't believe there'd be a fiscal note associated with it, although maybe I'm wrong, but that we would like to reconvene and continue to operate as a bipartisan body to the extent there is more data to be gathered and more analysis to be done.
Okay.
Thank you for the question.
Does anyone else have any questions or comments? Senator Kroon.
Thank you, Mr. Chair. Looking at the letter that the chiefs of police and the Sheriff's Association submitted to us, and one of their concerns is the preliminary application process requiring an initial review by a Ramsey County District Court judge rather than the county where the conviction took place. Can you explain why that's the route you chose to go on this?
Thank you,
Professor
Senator. Mr. Chair. In this particular case, there were actually members of the County Attorneys Association on the House side who played a pretty pivotal role in drafting this provision. And one of the concerns that they had was having a bunch of petitions, some that might not be meritorious, come from all parts of the state to judges or courts that might not be particularly attuned with the law change. And so they believed that having a clearinghouse of sorts, a single, whether it's a special master or another single authority with intimate familiarity with the law change and what they'd be looking for, do sort of a first cut at the applications as they come in, and then send the meritorious applications back to the original counties for processing would be the most efficient way, and it would burden the stakeholders, the county attorneys, the judges, the least amount. And that was the rationale, and that was what the rationale that was stated in the House on Tuesday as well. Thank you for the question.
Senator Kroon.
Thank you, Mr. Chair. So when the initial preliminary application for goes back to the counties of conviction, do they have a decision-making role at that point?
Thank you, Senator.
So, Professor Moriarty.
Mr. Chair. Absolutely. They would be making the ultimate decision on the merits.
Senator Kroon, any follow-up?
Thank you, Mr. Chair. The other one I was going to ask about is the last one, and I don't know, this is on the back page, and it's their last concern about right to appeal. It's their opinion that a subdivision should be added, providing that the parties have the ability to appeal and either set the language out in the statute or reference Minnesota statutes 590.06. Do you care to comment on that?
Professor? Ms. Deagle.
Oh, thank you. Thank you, Mr. Chair. Thank you, Senator, for the question. Yes, that has been added. That was part of the A6 delete all bill that was added today. You can find it at lines 719 and 720. Yes, you can find it at lines 719 and 720. That was the, that allows for an appeal of the order issued by the court of conviction.
Thank you. My mistake.
Senator Kroon.
I hadn't gotten that far yet.
Not at all.
Thanks.
Not at all.
Any further questions or comments from members of the committee? All right, Senator Limmer.
As I look on page 1, Mr. Chairman, there's a reference to liability for murder committed by another retroactive application. Could you explain that to me? We rarely make retroactive provisions in law, and so this is a unique request in the form of legislation.
Ms. Moriarty.
Thank you, Mr. Chair, and thank you, Senator Limmer. Yes, the intent is for this law to be a retroactive change that applies to those who are currently serving sentences that we believe are, in some cases, grossly disproportionate to their culpability. This is one of those instances when our law change is reflective of something that we know both about assigning liability when it's not warranted, but also about punishment that far outweighs the role that somebody played. And in those instances, it's certainly our position as a task force that this law should apply equally to those who may commit an offense tomorrow, as it should to those who've committed the offenses previously, because the real disparity in culpability isn't really a matter of time. It's just a fundamental decision that we're making about correcting a wrong and recognizing that there are people that are and have been languishing in prison for quite a long time for doing the things that Megan and Brianna and Jamesia did. And that's really, and I do understand the question, and I appreciate the concerns about retroactivity broadly. But in this case, and I submit in other cases where we have similarly disparate punishments, it's essential.
Mr. Chairman,
Senator Limmer.
going back to the letter from the Chiefs of Police and Minnesota Sheriff's Association, they require the Commissioner of Corrections to identify and notify persons who may qualify for relief. They're stating it's not clear to us how the Commissioner is going to ascertain whether an offender did not actually cause the death of a human being. So how would a Commissioner of Corrections do that?
Ms. Deagle.
Thank you, Mr. Chair. Thank you, Senator Limmer, for the question. So subdivision 2, which begins on lines 2.7, states that the Commissioner of Corrections shall notify individuals convicted of specific Minnesota statutes. So I'm not sure if the version that the sheriff's associations had maybe had different language, but the bill before you, Senator, does not require the DOC to conduct any sort of analysis to see whether someone would qualify for relief. The issue or the legislation just requires the DOC to notify individuals who had been convicted under specific statutes. But it is possible that the Sheriff's Association had a different version, and we're concerned about that. But from the legislation before the committee today, it does not seem to present an issue.
Mr. Chairman, also in the letter, I know that Senator Cruin made reference to this preliminary application process requiring initial review by a Ramsey County District Court judge or an appointed special master. Why Ramsey County?
Professor Moriarty.
Chair Latz and Senator Limmer, thank you for the question. I confess I don't know the answer to the question why Ramsey versus another county, but I believe at the time, unless Ms. Deagle does, the county attorneys who were particularly involved in drafting that position, that provision of the bill, believed that there was enhanced capacity. Is that your understanding?
Yeah, that's my.
That's Ms. Deagle's understanding as well. That is why Ramsey County was chosen. I believe there's been some other experience in Ramsey County with designating special masters to play a clearinghouse type role like this, but that is certainly something we can get more information about and provide it if it would be helpful.
Mr. Chairman,
Senator
as I was trying to formulate it in my mind, I thought perhaps maybe going back to the judicial district of original jurisdiction would be more appropriate. I understand that maybe a special master or a specialist judge could handle these things perhaps in a more expeditious manner, but I don't know if that would really be a great enhancement to the process. Do you have any further Was it considered that going back to the original jurisdiction?
Ms. Deagle.
Thank you, Mr. Chair. Thank you, Senator. As I recall, and Professor Moriarty touched about this, there was concern about capacity in some of the smaller courthouses in the state. If there was going to be a deluge of preliminary applications, I think the concern was with capacity in smaller districts who maybe only have one or two judicial officers, and that the existence of a special master, as Professor Moriarty said, kind of like a clearinghouse, would help alleviate that issue, because then the applications or petitions then that are going to the courts or conviction have already passed kind of a prima facie review, and so you would not be dealing, these judges who are maybe the only judge in the courthouse aren't dealing with frivolous applications. That was the intention.
Mr. Chairman, I remember looking at the page that you presented, 48% of people involved in this status were from Hennepin County, 4th Judicial District. Very few were showing in some of these small counties that you're referencing. So I'm not quite sold on the idea that a small county would be overburdened by that in using your own information.
Thank you, Chair Latz, and thank you, Senator Limmer. No, I appreciate the question. I think another piece of it, candidly, was the efficiency that will inure to a single person who's familiar with the criteria and will see the entire universe of applications and will be able to sort frivolous from non-frivolous applications. I think, candidly, I believe that the concern on the prosecutorial side, and I do understand it, is that there will be thousands of applications. We don't think that will be the case, but that a single entity charged with sorting through everything and doing so quickly and being able to compare and contrast the applications would be particularly efficient. And then there was certainly appreciation of the desire for local districts to have cases back to make the ultimate decision on the merits. And those would go back to the county of origin to decide whether or not relief was warranted, and they would then mete out the relief. So I do believe that it was an efficiency decision and not one that was meant to deprive the county of origin of the ability to determine the merits.
Mr. Chairman, I have two more questions and then I'll be done.
Senator Limmer.
Thank you. During your first task force, as you gathered information, my experience has been I listened to those who pursued a task force a few years ago. I haven't heard from victims' families. Did your task force interview victim families, and could you tell me or tell the committee what that response was?
Ms. Cater.
Thank you, Chair and Senator. So I was a part of that piece of we broke into 3 groups and focused on that. I worked with the victims advocate that was on the task force, and I believe we reached out to over 100 organizations statewide, public defender's office, or prosecutorial offices, victims' rights groups, et cetera. So we did do a mass outreach looking to interview families of victims. And again, we reached out to the local Minnesota Alliance on Climate. I believe they represent like 75% of the victim organizations within the state. We, Bobby from MAC, did interview with and spoke with during our time a victim's mother
who spoke about her son's death, and that the person who was not at the scene was charged with murder, and the person who murdered her son was never charged, which we know happens in these cases. And so we did do all of our due diligence. We kept explicit. I did have outreach from people in those units, but we did not have a big response from victims' families, which is not necessarily surprising, as I would suspect that a lot of them don't want to reopen those wounds.
Senator Limmer.
During your task force, I'm assuming you looked at other states to see what kind of treatment of felony murder might or might not be. Were there any provisions that recognize perhaps the age of the defendant, perhaps immature or not quite of majority age, or perhaps a little over majority age? We've heard off and on in testimony that mental acuity and reasoning is not fully developed until mid-20s. And so is there any state out there that bifurcates that population a little bit and recognizes that if you were convicted of felony murder at a younger age, the court would recognize that lack of judgment, and that then would predicate a release or a non-conviction? Chair
Professor
Latz,
Moriarty.
Senator Limmer, thank you very much for the question. The research that we did was really on the liability provision, how aiding and abetting and felony murder may or may not work together in states, and whether there were limitations imposed depending on participation and roles. But there are states that in their sentencing laws, and they're mostly in juvenile sentencing laws, have attempted to, at this point, establish gradations for punishment based on both age and maturity, but also relative participation. So it's a terrific question. I mean, there have been efforts to lobby the U.S. Supreme Court to, for example, abolish life without parole for anyone who's charged in a felony murder type scenario, because the culpability is lower. There are multiple actors, which is, part and parcel of what teenagers do. They succumb frequently to peer pressure. So it's a terrific question. It wasn't within the ambit of the research that we did, but it's certainly a consideration that we would urge sentencers to make in that context, and perhaps would be part of a law to have sentencers look differently at children.
Thank you.
Thank you, Mr. Chairman.
Senator Limmer, I was all primed to make sure you abided by your self-imposed cap on the number of questions, but you abided by it on your own. So, Senator Kroon.
Thank you, Mr. Chair. I'll make no such promises. Just kidding. I'm kidding.
You might be better off if you did.
I'm serious. Yeah, just one additional thought, and I'll just throw this out there because and I don't want to second guess the task force work. But the foundation behind this, the principle behind it, it seems to me, and I'm not a prosecutor, but one of the great benefits of the felony murder statute, the existing one, it seems to me, would be the incredible leverage that it would apply to get people to talk, to get people that were there to talk with authorities, to get to the bottom of what happened, and use that leverage, and not necessarily to prosecute people under this statute, but it seems like it would be an incredible tool if I were a prosecutor, and to just summarily take that tool away from prosecutors concerns me. I don't know if you've had any discussions with prosecutors or if that came up on the task force, which I'm assuming they were part of, but if you could elaborate a little bit on that, I appreciate it. Thanks.
Professor Moriarty.
Chair Latz, and thank you, Senator. I would say that the prosecutors on the task force, in this case, it was Dakota County Attorney Kathy Keena and Pat McDermott, who I believe is from Blue Earth, were both MCA designees on the task force. And
I talked quite a bit with Dakota County Kina about what the data showed and her thoughts about, sort of precisely what you just laid out. And honestly, she expressed concern about the fact that it appeared that there were counties that, in some cases, overcharged in an effort to gain leverage over less culpable participants, and explained to us that in Dakota she has a very stringent set of criteria she applies to essentially charge in accordance with culpability. And what ultimately happens, we found, and in particular in certain counties that had a disproportionately large number of first-degree felony murder charges, is that the charges are levied. There's hope of cooperation. If it doesn't happen and someone exercises their trial right instead, the charge of first-degree murder remains. And then the principal ends up testifying against the aider and abetter. So we have 5 cases in this state where the person who caused the death, who committed the murder, is serving less time than the person who was there but not handling the weapon and did not commit the underlying act. So I understand the question. I think it's, there are laws that can be used as tools to gain leverage. I think it's fair to say the reason that we were a unanimous task force in this case is that the data showed us that those laws weren't being used fairly across the state. And some county attorneys, I think, do it very fairly and do it very well. But that's, I think, the difficulty here.
Senator Kroon.
Thank you, Mr. Chair. This will be my final comment. I appreciate the response. My concern with the statistics is that there may be 5 cases, like you mentioned, where the person who aided and abetted is serving a longer sentence than the primary perpetrator. But what we don't have, or maybe you do, but would be the number of cases that weren't charged that did successfully aid the investigation and the prosecution of somebody that ultimately was responsible. And I'm not sure that that would be reflected. And that's really what I'm getting at, is how many cases did the threat of this statute allow our investigators and prosecutors to get people to open up, and that they ended up never charging them with this statute. But it really helped a successful prosecution. And so that's my end concern with this, and I'll leave my comments at that. Thank you.
Any further discussion? Members, the plan here is to lay the bill over for possible inclusion in the committee's budget bill. So at this time, Senate File 1478 is laid over.
Thank you.
As amended. All right. Members, we're going to take up Senate File where's this one here, 1950. I will tell you also that the plan is to lay this Senate file over. So we'll take testimony and so on. I'll note it's 5:30 on a Friday. Thank you, all of you who have waited around for this bill to be considered. I'm going to ask members to kind of keep focused on the topic at hand, and so that we can make efficient use of our time here. Senator Umu Verbaeten, whenever you're ready, go ahead and introduce your bill.
Thank you, Mr. Chair. The length of our probation terms in Minnesota are failing basic tests of fairness, wasting resources, and not achieving our goals of reducing recidivism or increasing public safety. This is why you'll see before you today Senate File 1950, a bill that imposes a 5-year probation cap for certain offenses. While Minnesota has the 6th lowest incarceration rate, we are the 6th highest state in the country for probation length. And Largely, it is a good thing that we focus on probation over incarceration. Community supervision has a number of benefits, and if it's done well, can be much more tailored to help individuals succeed and reintegrate. And those on supervision can spend time with their family and pursue careers in education. But probation is still punishment, and the balance has tilted so far towards probation that the average probation term in Minnesota is far longer than the average prison term. In part, that's because Minnesota's probation limit was the statutory maximum penalty for the offense, and that can be as high as 40 years. And Jennifer Schroeder, who's here with us today, who has a 40-year probation sentence for a drug offense, will testify to that. She'll be over 70 years old when her probation sentence ends. The Minnesota Sentencing Guidelines Commission took action in 2020 to limit probation to 5 years, except for homicides and criminal sexual conduct. This bill would codify the actions of the Sentencing Guidelines Commission and would take a step they were unable to do by righting past wrongs and making this provision retroactive. I will leave it there and pass to our testifiers. I think we'd like to hear from Jennifer Schroeder first.
Before we do that, I want to make a note to the members of what's in the packet. Mr. Backus, do you want to explain? We have a couple of amendments in the packet, and I'm not sure, as we're listening to testimony and reviewing what's in front of us, what we should be paying attention to. It looks like there's some overlap between the A1 and the A3 amendments in the packet.
Mr. Chair and members, the A3 supersedes the A1. So if the and I believe the A3 is in your packet, so yeah, you would proceed on that and not the A1.
All right. Thank you. Ms. Schroeder, go ahead. Welcome to the committee.
Thank you, Mr. Chair. My name is Jennifer Schroeder. I come from a very broken home with very broken people. I never thought to myself when I want to grow up to be an addict, but that's what happened. Addiction became a part of my life very early on. Some traumatic things happened in my family, and it slowly consumed me till it was the only thing I knew. I bounced around from foster homes and group homes. No one ever stepped in to be a role model for me. And unfortunately, into my teens, I began selling drugs. My rock bottom came when my newborn daughter was taken from me from the hospital due to a positive drug test. 3 weeks later, I was arrested for driving without a license, and I had drugs on me. I went to jail. I was sentenced to a year in jail and 40 years of probation. At the same time, I was fighting my CHIPS case. My daughter was coming to see me in jail. When I was released, my daughter was visiting me in the halfway house that I was at, and I was fighting towards reunification. And after the year timeline came, the judge pulled the rug out from under me and terminated my rights. And I did not turn back to drugs. I fought very hard to get where I am today. I had no credit, no car, no license, never had a checking account, no family support, nowhere to live. I had to give up everything and everyone I knew and start from the ground up. I bused 2 hours one direction to school my first semester and earned a degree in addiction counseling. I have been working with the ACLU on a lawsuit for voting rights, which we signed into law this morning. And still, I will never be able to travel with my son outside of the country and see the world because I can't have a passport until I'm 71 years old. I can't own a gun. I can't go hunting with my son. I can't have a gun for protection in my home. All this is very overly. And let me say, I did do my accomplishments under 5 years, for sure. I accomplished so much under 5 years, and probation was an excellent tool for me when I first was released from jail. My probation officer came to my college graduation. Probation is great, and it works well. 71, though, nobody is benefiting from me being on probation till I'm 71.
there should be no reason that anybody is on probation for 40 years. It wastes resources that can be poured into the broken treatment systems that could prevent these things from happening to begin with. I really hope that you'll support this bill. Thanks.
Thank you, Ms. Schroeder. Mr. Cooley, go ahead, identify yourself for the record and testify.
Chair Latz, members of the Judiciary and Public Safety Committee, my name is Will Cooley from the Minnesota Justice Research Center. As part of our work, the Minnesota Justice Research Center has been speaking to scholars, corrections executives, probation officers, and people on community supervision. While they have many ideas on how to fix the system, all of them agree that the growth of the state's probation population has overburdened local and state agencies, deteriorating the ability to provide the best returns on our public safety investments, deliver rehabilitation, and establish accountability. We are consistently hearing two themes. One, community supervision is underfunded in Minnesota, and two, we can use our current supervision resources in a smarter way. A major factor driving the size of the probation population is excessive terms on supervision. In Minnesota, people can spend years, even decades, under probation supervision. When the libertarian magazine Reason ran a recent investigation on how the American probation system has become a criminal justice quagmire, it featured Minnesota as an egregious case. The article shows that the push for reform is coming from across the political spectrum. We have consulted with Scott Payton from Right on Crime. Scott is a policy expert and experienced probation officer, and something in particular he said stuck with me. The key to success on probation is clients seeing a pathway off of supervision through accessing community resources. As you heard from Ms. Schroeder, that does not exist when probation sentences are unreasonably long. Probation is punishment, and punishment works best when it is swift, certain, and fair. Studies on optimizing the effectiveness of probation show that the vast majority of clients could be on supervision terms on shorter supervision terms without an impact on recidivism. Oregon, a blue state, and South Carolina, a red state, have led the way on research by providing high-quality data. Among people who are on probation for a year without being arrested, more than 90% could have spent less time on supervision. These findings demonstrate by right-sizing probation terms, we can focus our resources on the people who are being rearrested. In 2020, the Minnesota Sentencing Guidelines Commission approved a presumptive 5-year cap on felony probation lengths. The 5-year cap guidelines are not retroactive, however, excluding thousands of Minnesotans. SF 1950 remedies this by standardizing probation lengths and allowing community supervision agencies to do the vital work of preventing crime. Thank you.
Thank you, Mr. Cooley. Carly Stark is also on my list here, so if our two testifiers that are up here now could go ahead and return to their seats in the audience, and Ms. Stark will come forward. Ms. Stark, please introduce yourself and go ahead.
Thank you, Mr. Chair, members of the committee. I'll make up for the long walk with a short testimony. I'm Carly Stark from the Minnesota Association of Community Corrections Act Counties. We represent the counties that supervise about 70% of the probation population in Minnesota. We support this bill. There's national research and local research that shows that if someone is on probation much more than, or people are not likely to reoffend after the first 3 years of probation. And we base our decisions on research. So we also did some of our own research, and I did some data collection from 2017 and 2018, which is right before we heard this proposal last time. And 84% of cases in CCA agencies already have probation terms of less than 5 years. So we don't think that this cap is a big change from standard practice. I'll stick around for questions. Thanks.
All right, thank you. I see Commissioner Schnell is here. Did you wish to add anything, Commissioner, in addition to what's already been provided to the committee?
Mr. Chair, just, and committee members, just briefly, I would just say that, as was mentioned, probation caps reflect evidence-based policy. Probation caps address the issues of justice by geography, or the inequity in probation terms that we've heard about. We know that revocations drop precipitously within the first 2 years and are minimal after 3 years, which was why the Guidelines Commission took the action it did. And in closing, I would just simply say that probation caps reflect sound public safety policy and responsible stewardship of public resources. Thank you, Mr. Chair.
Thank you, Commissioner. I see, appears that Robert Small wishes to offer some testimony here as well. Mr. Small, come on forward. Is there anyone else in the members of the public that wish to be heard on this bill? All right, I don't see any. Mr. Small.
Bob Small with the County Attorneys Association. We've been trying to get a meeting with you.
Go ahead, Mr. Small.
Oh, thank you very much, Mr. Chair, members of the committee. My name is Robert Small, and I am the Executive Director for the Minnesota County Attorneys Association. I know the hour is late. You've been here since 9 o'clock. I've been here since 9 o'clock, so I'm going to be very brief.
Earning credit here, Mr. Small.
Yeah, right. So 3 key points I'd like to share with members. One, our association has long been at the forefront of appropriate lengths of probation. We opposed the sentencing guidelines doing it because we thought it was a legislative function and not the function of a commission. And so, as I said, we've long been at the forefront on appropriate limits for probation. Secondly, the second point I'd like to make, as the guidelines currently allow for, and a judge in many circumstances, and Senator Latz, I know you trust the good judgment of judges. And so judges all the time make decisions about what are substantial and compelling circumstances. And in the current sentencing guidelines, the judge is permitted to go beyond the 5 years if the judge can articulate substantial and compelling reasons to do so. This bill lacks that opportunity for the judge to exercise that ability, as the judge always does on downward departures. Lastly, retroactivity. There's a concern with retroactivity in the automatic nature in which the current bill provides that all those can be converted to 5 years without a process of victim notification, without a process of discussing outstanding restitution to the victims, without prosecutor review or input. And we would prefer a framework that incorporates those elements. Thank you very much, and unless there's questions, good night and have a good evening.
Thank you, Mr. Small. Okay, we'll open up the conversation here to the committee members. Ken, we have we have an author's amendment to address here. So Senator Uma Verbaeten moves adoption of the A3 author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. So I have a question for Senator Uma Verbaeten. The county attorney's office, or county attorneys, did provide a letter indicating some suggestions for adjustments to what's in the bill, even some suggested language. Have you had an opportunity to take a look at that, and what are your thoughts about it, Senator?
Thank you, Mr. Chair. Yes, some of the initial, some of the changes that were adopted in the most recent amendment, we're addressing concerns around disparities for low-level felony offenses and then gross misdemeanors. And there's still going to be some disparities that we'll need to address as we continue to work on this bill. One of those was around the first initial strike from 6 to 5 on page 2, line 19. We moved that down to 4 because of the other adjustment that was made on page 2, line 13. So that was an initial change we wanted to work through. The pieces around retroactivity, that's a conversation that's ongoing that I'll continue to have with House Author, Representative Long, and the County Attorneys Association. And if I may, I wanted to try to keep opening statement as brief as I could. I know it's been a long day for us, but one of the concerns is just that there have been some disparities in how this has been applied across our state. So, there's areas where the average probation length is 3 years and then where it is 7 years. And even after there was that action from the Minnesota Sentencing Guidelines Commission, there's data that's been pulled on where there's been those departures. There were only there were 52 judicial departures in the 7th Judicial District, while there was only 1 in the 4th and 0 in the 6th. And so that's part of why we're looking to legislate some of this, because there are concerns about how judges are applying it. So again, the conversation's ongoing. I completely understand the questions around retroactivity, and that's something that we'll continue to work on. But this is what we have before us right now.
All right, well, you'll have an opportunity to keep working on it because the bill is going to remain in committee for a little bit yet. Any other questions or comments from members of the committee? Senator Limmer.
Mr. Chairman, did I hear you correctly? This will be held over?
Yes.
Okay. Then just a few brief comments, Mr. Chairman. I know historically that probation services across state have been underfunded. We tried to address that in the last 2 years by living up to a promise that the state made 2 counties to cover at least 50% of the probation costs at one time. We were going in that direction, but the bill did not get to full fruition last year between the House and Senate. I did want to make a comment about probation terms, historic probation terms. We all heard the comment that Minnesota is a low incarceration state, and probation is a little longer in Minnesota because of that reason. We've relied on probation, it's cheaper, but because of incarceration being so low, probation became a little longer in term and also in reliance that we had. And so Minnesota does stand as an outlier, but there's the reason why. We knew that incarceration isn't appropriate for many people that are either in property crimes or in drug possession crimes. Those particular offenders need treatment more so than they need incarceration. Minnesota wisely moved in that direction about 45 years ago. We heard of the story of the 40-year probation, and that does sound excessive to me. But is it an outlier, or do we have a lot of that? And we haven't really heard the full description as far as the percentage of those on probation that are for that long of an extended time. I know that I've had my differences with the Sentencing Guidelines Commission on their limitation and cap on probation. I do rely on judicial discretion when we make policy decisions. I think judges are in the best spot to make that decision. I am also concerned about retroactivity. I would like to work with the author and work with the County Attorneys Association in perhaps addressing some of the current subjects that Judge Small addressed regarding a possibility of judicial upward departure in the event of severe cases. And before we come back to the committee, I'd like to work with the author and hope that we could come to some conclusion that a hard, fast line of 5 years, it almost is a one-size-fits-all, and quite honestly, that never really works well, in my opinion. And so I hope we can work together, Senator, and before we come back to this committee, we could work on that.
Mr.
Senator
Chair.
Mover-Baden.
Thank you, Mr. Chair. Senator Lemire, absolutely. I'm happy to work with you on this and continue these conversations. I just wanted to point out a few more things. One, that the bill does lay out some exceptions for some particularly egregious, crimes. The others just, and we heard this, but that those first 3 years are really key. And the data shows us that it's 1% or less of offenders that have their sentence revoked after 5 years. So, I think 3 years is a really important mark, and this bill is trying to give us even a little bit more buffer with 5. The other piece is these really long probation terms are taking up space, and that's part of why, we heard from MACAC, their support, because they want to focus on the folks who really need that support in the first 3 years, right? Lower their caseload because our probation workers are overworked and overextended. And there are other bills that are coming forward on just general reform on that process that I'm happy to support as well. But really think there's more details to be figured out. Absolutely, I'm looking forward to working with all of you on that. But I do think this is really trying to strike the right balance between lowering those cases, focusing on those first few years that are very important for folks.
Senator Lemire, Senator Kroon, any further comments?
Well, Mr. Chairman, since you invited
Just want to make sure you're taking care of Senator Limmer. If this goes too long, however, you're buying us dinner.
then I'll really be quick, Mr. Chairman. Thank you, Senator Mover-Baden. But in making our policies in this area, we still have to stay focused on the general recidivism rate that is much higher than what was represented on the probation side here tonight. So we have to get our figures apples to apples here. And it's probably because there's some definition that you're relying and I'm relying on that might be different. So that'll be part of our discussion as well. Thank you.
It appears that our conversation is drawn to a close on this bill, members. Senate File 1950 will be laid over as amended, will be laid over for possible inclusion in our budget bill. Members, thank you for your work today. I know it's a long day. Next Friday is a policy deadline day. So please plan to be here in person, if at all possible. I expect we'll have a robust agenda. Might go longer than today did. We'll see how the conversations go and what bills we end up putting on. But please plan with your families and others accordingly. And if our colleagues could let the colleagues who are not here know It will be much smoother and easier for them if they are present than if they are not, I mean, physically present in the building here rather than online. I also want to recognize our pages today, Diane, Natalie, Sam, and Callie, who did a great job. It's a good practice run for next Friday. So thank you for your excellent work. Made a big difference for all of us to help the committee run smoothly. With that said, members, we are adjourned. Have a good weekend.